there we have, I'll ask if Kimberly Seraphan is on the line. Right. No response from Kimberly Seraphan.
Oh, I'm here.
Okay,
Sorry.
all right, great. Thank you. Appreciate that. And then I'll ask if Eddie Seraphan is on the line.
Yes, Your Honor.
All right, welcome to you. Looks like Mr. Ball is joining the Zoom call right now. It's just kind of in process. It's got the joining and the ellipses, and he hasn't quite made it in yet. Mr. Ball.
Well, I just popped on. Morning.
Okay. Good morning. All right. As far as today's, one moment, matter, it's scheduled for a presentation from a hearing we held back on July 3rd regarding the contempt. And then also there was a temporary parenting plan that needed to be revised. So it said temporary as opposed to final. Yeah, so that's why I think we're here, and then the parties can inform me if that's accurate or if there's less or more. So, Mr. Ball?
That's correct. That's the presentation of orders. I think this is our third setting. We were with Judge Basha the previous two times, but there's, I think he signed the contempt order last time.
Yeah, I think that's accurate.
But the objection on the temporary parenting plan is that mother wants to add a few additional terms that the court didn't order. Like I think it's a parenting class and something else, and so the court didn't order that. So that's why I guess why we're here.
Okay. All right, Ms. Serafan?
Yeah, so originally when I proposed the parenting plan, I had in there anger management and parenting classes.
Okay.
And so that never got addressed, and I didn't realize that that was something that I would have to propose again. And so I don't have any legal representation, and I'm not good at going through all the paperwork and things like that. And so at this point, I was told to ask for a continuance until I had things kind of wrapped up, so I could figure out what to read over and how to do that. So I don't know if that's something you could grant until after I have my consult, or if it's something that you could add into there, then I wouldn't have any issues with how the parenting plan is.
Okay. So one thing, I appreciate that input. One thing to consider with a presentation hearing. A presentation hearing is a hearing where a hearing has already been held. There's been a ruling made by the court, and then the presentation hearing today is to make sure we have a document that accurately reflects what the court ordered on the prior hearing. So if the court ordered X, Y, and Z, and X, Y, and Z are included in the order, great. If the order includes X, Y, and Z, and A and B, but the court didn't order A and B, then it wouldn't be appropriate to include it in today's order, simply because it wasn't ordered at the prior hearing. If there's a request that was raised in the pleadings, but wasn't necessarily addressed at the hearing, then it should not go into the order, simply because it wasn't ruled upon. And sometimes if you're not normally involved in these type of proceedings, sometimes it's difficult to remember everything that needs to be addressed at a particular hearing. And sometimes the judge may not address all the things that you wanted the judge to address. And that's generally it's incumbent upon the parties to say, hey, look, judge, I raised this other issue and you haven't ruled on it. Could you please rule on it? And then it's ruled on at that hearing. So anything that's ruled on at the hearing is to be summarized in the proposed order. And if it hasn't been ruled on, then it should not go into the order. So that's kind of a general overview of a presentation hearing. So that ties into your request for a continuance. A continuance of this order seems to not be in order, simply because the issues have already been ruled on, and then this order that's being proposed today would summarize what was previously ruled upon.
Okay.
So I don't know if you have any further questions or comment about that explanation or the contents therein.
No, that really sums it up. Thank you. I know that we were waiting on the domestic violence evaluator, Sam. Previously, when I had talked to him, he wasn't done with his report for that. I don't know if that's something we're going to talk about today, if that's something that goes into the parenting plan.
Okay. Mr. Ball, any comments?
Well, it's ordered that he's supposed to do the DV evaluation and treatment, and so that's in the order.
Okay, I do see that on page 2. And then do you see that, Ms. Serafan, in the proposed order that Mr. Ball prepared on page 2? It says evaluation to be evaluated for domestic violence and substance misuse, for petitioner to provide collateral input, start and comply with treatment as recommended by the evaluation. and then to provide copies of the evaluations, monthly reports, or treatment compliance.
Okay.
So it looks like that's included therein.
Yeah.
Okay. And then as far as the, Mr. Ball indicated that as far as the parenting class and anger management, those are the ones that you were hoping would be added to the order. Is that correct?
Yes, sir.
Okay. And do you recall at the prior hearing, were those items ruled upon by the court?
No, my initial proposal was years ago, and then we had to wait until the guardian ad litem had done her report and all of her assessments, and so those never were brought forward into the initial proposal.
Okay. All right, thank you. And then, Ms. Serafin, from the order, the proposed order that Mr. Ball presented to you, when you looked over that, was there anything that you feel was inaccurate or not an accurate summary of what the court ruled upon previously?
No, it was accurate. There were some wording changes as far as like medical records obtained and just additional things, I think, that were added into it, which wasn't necessarily an issue at all, but I just didn't know if it legally meant any big changes for me or not. And so it was just different from the original parenting plan that I was familiar with, and that's all. I just wanted somebody to look it over to see, if that would in some way, I don't know, be okay.
Are there any specific provisions that caused you greater concern than others?
No, I think that the most important for me really is when I had spoken to do my part with the domestic violence evaluator, is that his report was supposed to be done and presented to you for recommendations a couple weeks ago. And so I just wasn't sure. I just want to make sure that everything's being done really that should be done.
Yeah, generally with evaluations, when the evaluations are completed, the order states that the evaluator's recommendations are to be followed. So
Okay.
it doesn't have to come back to court. So
Oh,
the
perfect.
recommendations are what they are, and then they're to be, the expectation is that they're followed and complied with.
Okay. That was my bigger concern. So no, I think everything on there was pretty much exactly what it had been summarized from the previous plan. So I didn't have any major objections. It's a lot to read over by myself. And so that's all.
Yeah, agreed. It is a lot. Okay. Anything else, Mr. Ball?
No, I would just request that the court sign the order, and I believe Judge Basher signed at the previous hearing 2 weeks ago, the hearing, contempt hearing order. I just wanted to check on that. So
I can confirm that the order of contempt was
Okay,
filed on July 24th. It was signed by Judge Basher on the 24th, and it's in the court file.
Okay, thank you, Your Honor.
So with that proposed order that was provided by Mr. Ball, and having heard from Ms. Serafin, I've signed off on it, and that will be filed. If parties need a copy, you can check with the clerk and get a copy of that. Otherwise, I think that addresses the issues today. Anything else?
Your Honor, I just wasn't sure about the visitations have because the contempt order was signed July 24th. My understanding is that he has visitations with the kids. It just has to be supervised, and that has never ceased because the contempt order wasn't overruled. Or is that right? I just wanted to, because he's telling my daughter that he can't see her because of his attorney's advice, and she's kind of been a wreck for about a month now. It's not really been cleared up.
Well, I think the mother hasn't allowed parenting time for over a year now, and we've been trying to arrange parenting time. He had 5 supervised sessions set up, and she canceled them all. And now he's not allowed to have phone contact. He's not being allowed phone contact. So it's ironic.
I'm sorry, that has to be
saying
his word because
he's not following the parenting plan. If there is a parenting plan problem, we're gonna have to come back to court on this to try to resolve it, obviously. But
Okay. Yeah. So I appreciate the input from both parties. So any issues related to the parenting plan? The temporary parenting plan has been signed today. So that's the order that controls from now going forward. And if the expectation is that the parties will follow that. If the parties feel that it's not being followed, you can try to work it out. If it doesn't work out, then the parties can bring a motion for contempt and the court can rule on it. Otherwise, the temporary order that was signed today, the parenting plan controls, and then the expectation is the parties will follow that. So any future concerns that can certainly be noted up for a hearing. Otherwise, yeah, we've taken care of the purpose of the hearing, which was the presentation. So that'll conclude the hearing. Thank you.
Thank you, Your Honor.
Good morning, Your Honor. Thank you for calling the case early.
You're welcome. Good morning, Ms. Holder, and good morning, Mr. Lawrence. I see that they're present. Mr. Jensen's present in the courtroom, and I'll ask if Megan Rhodes is on the line.
believe she is. I see her name in the box.
Okay, Ms. Rhodes, are you on the line?
Yes, I am.
Okay, all right, welcome to you. All right, let me just pull my notes up. Okay, we're here in relationship to the supplemental GAL report that was submitted on the 29th of July. Did all parties get a copy of that? Mr.
Yes.
Johnson, you got that?
Yes, Your Honor.
Okay. Mr. Lawrence, any highlights you'd like to spotlight from that report?
Well, Your Honor, the main issue was that both of the parties have been listening to folks telling them concerns that they had. However, there's never been any real evidence to support any of the allegations. And so at this point, I don't have any evidence to support that Ms. Rhodes is having a continued relationship with Mr. Pittman, nor do I have any evidence that Mr. Jensen is in jeopardy of losing his sobriety. So I cautioned both parties to gather information if they come up with further allegations in the future.
Okay. And then previous to that, the supplemental report, you made some recommendations related to a parenting plan.
I did.
Okay. And then I've read the separate, looks like Ms. Rhodes filed just recently declaration that was dated August 12th. Did you get a copy of that, Mr. Lawrence?
No, I didn't, Your Honor.
Okay. All right, very good. All right. Thank you, Mr. Lawrence. I appreciate that overview and highlight. I'll just hear from Ms. Holder and then Mr. Jensen. And then let me ask the parties, is the expectations that they would, with the recommendations from the guardian ad litem, there's a couple of ways to approach this. One is that the recommendations have been made. The court could take that and issue a ruling based on that and the input from the parties, or the parties can will have read the guardian ad litem report, and then the parties can subsequently file a motion for a parenting plan, which I think that's kind of where we're at, in that there's been proposed orders submitted for a parenting plan. But that's the other option, is to have a more full discussion based on those recommendations and have a hearing at a later date. So if you could just address that in your comments when you address the court, that would be appreciated. So Ms. Holder.
Yes, Your Honor. We had planned to just take this as an opportunity to ask some questions of Mr. Lawrence as far as his recommendations goes to further clarify. The proposed parenting plan that you have in front of you and that Mr. Jensen has is based off of what I assume would be some of his answers to my questions, but I'm happy to change the parenting plan if Mr. Lawrence has some different thoughts about it. We were going to file a temporary family law order after this to put the parenting plans into place, as well as child support worksheets and a proposed child support order, as that would be necessary in this case as well. So this opportunity for today is more or less to ask Mr. Lawrence some questions so that the court can take that clarification of his recommendations into consideration when looking at both my proposed parenting plan and Mr. Jensen's proposed parenting plan. Then we could set this out for 2 weeks and come back with any amended issues in our parenting plans, as well as a temporary law order for the court to sign off on, and also rule on child support issues at that time. I would say it's up to the court's discretion as to whether it wants to make any findings today, but it seems that the parties have been working pretty well under the temporary orders that have been in place so far. So I would leave that up to the court's discretion.
Thank you. Mr. Jensen.
I'm looking for Keith's recommendations. I just wanted to say some things. I don't know if you got these copies. I submitted them to the court. It's about Megan's substance abuse issues as well. Since this is mostly what my issue has been with not getting the 50-50 custody, is they don't believe that I have been, or that my sobriety would be in jeopardy.
Can I ask you those? When did you file those?
I filed them. I brought an extra copy for you to look at if you wanted to, but I filed them on Monday or yesterday.
Yesterday. Okay.
Your Honor, if I can simplify the procedural issue, he had filed them. He set a hearing for September 3rd. It's for a motion and order for a hair follicle test. And Mr. Jensen and I discussed that yesterday when he dropped his notice of hearing and the documents off at my office. I told him I would be happy to hear this today if the court wanted to hear it. He did file it. It's very simple. It's just a motion for it's a motion for Miss Rose to have hair follicle testing, which what we filed yesterday, if the court can see, we already filed a submission of a negative hair follicle test that she already took back in June. So
that's also what I wanted to bring up is it says it's negative. She failed it for alcohol. If you read this, it says that she has substance abuse issues. Alcohol is a substance. So she's saying that I'm not sober, yet she's not sober.
Okay, so generally, I don't know what your declarations have said.
So I don't have an attorney, so I haven't written a declaration. I have this written down. I could file it later. It's kind of what I wanted to go over today.
Okay. So yeah, so as a general rule, in order to hear a particular motion or a viewpoint, both parties have to have reviewed it, had an opportunity to respond to it, and for me to have read it. I haven't read anything. Ms. Holder hasn't read what you're asking for, in detail. So we're not going to address that today. It sounds like you've noted up for September 3rd to have that issue addressed. Is that
That's
correct?
for the hair follicle test, but she already submitted a hair follicle test. I just wanted to go over like why I feel the 50-50, because she said in her declaration that she's wholeheartedly agrees with 50-50, just depending on my sobriety. But my counter to that is that she's not sober, and it shows in that hair follicle test that she tested or that she did, and that this is a GAL report from her previous her other child's case, stating that they have found that her and her ex had substance abuse issues.
Okay, so let me ask you, Mr. Jensen, the kind of the two approaches we could take today. One is that we've had the guardian ad litem report, and the court could use that and look at that information and make a decision of what the temporary parenting plan is going to be. The other option is to allow all parties to submit additional declarations or information about their points of view, kind of in relationship to the guardian ad litem report, and then come back in roughly 2 weeks to address it, and then the court would make a decision on the temporary parenting plan. From my perspective, I've kind of shifted in the past. In the past, I've just kind of gone off the guardian ad litem report and made a decision. I think it provides a greater sense of input and maybe fairness if all parties have an opportunity to chime in on the guardian ad litem report and discuss it from their particular point of view. I think that gives a more robust picture and a clearer picture. So I'm leaning towards not making any decision today on the temporary parenting plan, and then come back and allow the parties to submit declarations, and so I better understand your particular concerns and viewpoints.
Yes, because this kind of goes upon what I had been telling Keith that Megan had substance abuse issues.
Mm-hmm.
I didn't know how to go about it, but then I went to the courts and found this stuff in Clark County for Megan's, and that's more proof that she did have a substance abuse issue. Because I was trying to tell Keith that, he said that there's no evidence. No, there's this from the other GAO report, so I would like to submit this and that.
Okay.
And Your Honor, if I may, I know what case he's talking about. He has the public report that does not have all the information. He just has the recommendations from the GAL. I would be happy to provide that to Mr. Lawrence. However, there is some new legislation that just got passed. It's the My Health, My Data Act. I'm not sure if the court is familiar with it, but there's some question in the legal community as to if we can share that or documents like that, because it has protected health data and third parties are not supposed to be sharing it. So I would be happy if the court would direct Mr. Lawrence to look at that report. It is cause number 13- out of Lewis County. Mr. Jensen does have the public version of it, but he does not have everything. I have reviewed it, and I would be happy for Mr. Lawrence to review that as well. There's nothing in there that really addresses Mr. Jensen's allegations beyond that both parties should just maintain their sobriety when they're around the child.
Okay, thanks. Mr. Jensen, do you have any concern if I were to grant access to Mr. Lawrence to look at that full document?
This full document?
The guardian ad litem report and the other matter that you're talking about, that there was concerns related to sobriety of Ms. Rhodes.
Yeah.
Okay.
What was the question?
So, are you okay if I grant to Mr. Lawrence access, permission, authority to look at the full report, basically the full details of the report, not just the summary of the report?
Yes.
Okay. Does that need a particularized, just an order?
I'm not sure, Your Honor. We're all kind of unclear about what the law is regarding that, but I think if it comes from a court order, it should be okay. I'm happy to draft something. It's just, if my client consents, that's one thing. But I think in this case, if the other party consents, that's what we need. So both parties consent to it. If not, I'm pretty sure if the court can view it, again, we're just very unclear.
Meaning the other party, meaning from the other party and the other cause.
Yes, this would be Mr. Thomas Bailey. So I'm not sure if we would need his consent because it does include health information for him. And I don't want anybody, in my office or the court to step in it, legally speaking. But I would be completely fine with Mr. Lawrence reviewing this GAL report. I don't see anything in there that's going to be a problem. But because Mr. Jensen is referencing it as part of his arguments, I think it would be important for Mr. Lawrence to review it as well as the court.
Okay, great. Mr. Lawrence, do you have any questions?
The only question, Your Honor, is could I have that cause number again?
Ms. Holder?
Yes, Mr. Lawrence, 6. And that is a 2019 case out of Lewis County.
Thank you, Your Honor.
2019 case?
Yes, Your Honor.
And it starts with a 13?
I believe the what I have seen is that the order or the signature line has been submitted in 2019. So it might be an ongoing case that started in 2013, but the GAL report is from 2019.
This also says Superior Court of Washington for Cowlitz County, not Lewis County.
Okay. And what's the cause number on your document?
This document that I have right here.
Yeah, about the GAL report.
It's 13-.
So it's the same number that Ms. Holder had mentioned. And then does it say Lewis or Cowlitz?
On both of these, it says at the top, Superior Court of Washington for Cowlitz County. This one was whited out and somebody wrote Cowlitz County.
Okay. Let me just take a quick moment just to verify. So there's a little bit of confusion which county, and that would be helpful if we can clarify that. Okay. The clerk checked it up and she said it's a Cowlitz cause number. So and for purposes, the reason I just clarifying for purposes of this bench order that I'm drafting. So I've drafted the following. GAL Lawrence shall have full access to Cowlitz County Superior Court cause number, especially the guardian ad litem report, and I put 2019. So we'll get that filed, and then Mr. Lawrence can take a look at that if he chooses. So I think we've settled upon that the matter would be set over 2 weeks to allow all parties to submit their declarations, their information related to the recommendations of the guardian ad litem. And then we'll be back here on 28th of August and just want to confirm with the parties if the 28th of August is a date in which you could be available. Mr. Jensen?
Yes, and so that means that the one on the 3rd is no longer, right?
Well, we could combine them.
Well, it's a motion for a hair follicle test and she already submitted her hair follicle.
Yeah, and maybe to avoid duplicate or repetitive motions, maybe we could just set it all the matters to September 3rd, the one that you've already noted up, and then this matter as far as the recommendations, and just do it on the 3rd.
Your Honor, I just checked my calendar. I'm actually out of the office on the 28th.
Okay, would the 3rd work for you? I think
yes,
that's
Your
the
Honor, that would be
date.
fine.
It says that I think it was the 3rd at 1 o'clock.
Oh, what docket is that, Madam Clerk? Yeah, let's move it. Would you mind if we moved it to the 4th Wednesday morning?
Yeah, that works.
Okay, Ms. Holder, September 4th at 9 a.m.
Yes, Your Honor, that would work for my calendar as well.
Mr. Lawrence?
I'm available, Your Honor.
That's great. Thank you. Well, let's plan on that. September 4th, we'll hear your motion that you previously docketed for the 3rd. It'll be on the 4th. And then the motion related to the guardian ad litem report as it relates to the parenting plan. Basically, we'll make a decision on the parenting plan on September 4th.
Your Honor, would that time be appropriate on the 4th? Would it be appropriate now to ask Mr. Lawrence questions for clarification about his recommendations in his GAL report that he's already written?
I would think now would be better because that information's out there and parties can rely upon it in their responses.
If the court will allow, I just have a few clarification questions for Mr. Lawrence then based on his recommendations.
Sure, go ahead, please.
Okay. Mr. Lawrence, do you believe that 191 factors are appropriate in Section B for substance abuse for Mr. Jensen?
No, not at this time. He underwent inpatient treatment. He's in an aftercare program at this point. There's no indications that he is relapsed. And so at this point, I'm not thinking that 191 would be in play right now.
Okay. Would you recommend random UAs or something like SoberLink at this time?
Yes, I think that would be appropriate.
Okay. In your recommendations number 9, you recommended that Mr. Jensen not drink in front of Nora. Would you also recommend that he not consume alcohols within 8 hours of being around Nora?
Yeah, that's normally the standard verbiage that we use. I don't know why I didn't specify it that way. I just wrote it out that he not drink in front of her or drive under the influence of drugs or alcohol with Nora.
Right. And in number 8, you recommended that Mr. Jensen continue his treatment. Currently, he is an Alcoholics Anonymous, which by definition is anonymous. AA doesn't typically release compliance reports available through that would be available through traditional treatment. What recommendations would you make to ensure that Mr. Jensen is still engaged in some type of treatment?
Well, in normal supervision circumstances, the person going to an AA or NA meeting can have a slip initialed verifying that they attended on a particular day. And I would think that Mr. Jensen could do that and then submit copies of those to the parties.
Would you also recommend he submit it to the court as well?
Yeah.
Okay. And you've recommended that the current visitation schedule stay the same, which is Thursdays at 5 p.m. till Monday at daycare drop-off. Is that still your recommendation?
Yes. And the reason I went with that is that Nora's only a year old. And she's I didn't want to create a situation like a week on, week off right now until she gets a little more developed and secure in her relationships with both parents.
And you would recommend that a week on, week off start when she's 3?
Yeah, then when she's a little older and more secure in the relationships, then I would suggest that the court consider a week on, week off if all things are still equal. That Ms. Rhodes is not involved with Mr. Pittman and Mr. Jensen is still in compliance with his treatment. Then to do a week on, week off so that there'd be further building of the relationship. The problem you run into, though, is with the parents living in different communities. When she becomes of school age, then the week on, week off doesn't work. And so we'd have to revert to a more traditional parenting plan at that point.
And for recommendation number 10, that you recommended no contact between Nora and John Pittman, would it also be a recommendation that she's not to have any contact with any convicted sex offender or anyone with pending sexual assault or abuse allegations?
Well, I mean, that could be for both parties. Right now, the situation was that she had a relationship with Mr. Pittman. I addressed that specifically. It's going to require, if the court chooses to go with your recommendation, it's going to require for Ms. Rhodes to be able to access the sex offender registry and make sure that all the parties that she may come in contact with are on that registry or not on that registry, and whether that registry is current or whether they've even been convicted. There could be a sex offender that has not been convicted that she comes across. I don't know where you draw the line, but obviously the goal here is to protect Nora from any kind of a sex offender. And Mr. Pittman was a convicted sex offender, and that's why I limited it to him at this point.
Okay. I've added, has my office sent you our proposed parenting plan, Mr. Lawrence?
I haven't seen it.
Okay, my apologies. We will get that to you. I've included in section 14 of my proposal a few things, and I'd like to run those by you to get some opinion. I believe they're based off of your recommendations. I've recommended that no alcohol be around the child during Chris Jensen's residential time. Would you agree with that restriction?
Yes.
It'd be about both, but.
And I've also included in section 14 that Nora is to only be enrolled in one daycare at a time, and that if that is to change, it needs to be agreed by the parties. Do you agree with that?
Yeah, I know that Ms. Rhodes had some concerns about, the parents have separated now. There's two separate households. Nora is currently in a daycare in, I believe, Woodland. And her concern was to have a second daycare in the Chehalis area could further, I guess, potentially make it so Nora might not be as secure.
So your recommendation is that at 1 year old, that Nora just be enrolled in one daycare instead of multiple daycares?
At this time, should the court agree to a 50-50, both Chris and Tiffany, his significant other, both work. And so there would have to be some arrangement, and to take the child to Woodland in order for the daycare, unless Mr. Jensen is working in the Vancouver area and could transport her to her normal daycare and pick her up on the way home. I think we're going to have to address that one down the road when Nora gets a little older and we're looking at a 50-50 situation.
But just to reiterate, at this point in time, you do not recommend a 50-50. It should stay the same based on the age of the child.
Correct.
Okay, I have no further questions for Mr. Lawrence, Your Honor.
Mr. Jensen?
Thank you.
Mr. Jensen, do you have any input or questions?
I just had, I was wondering if Mr. Lawrence would be open to me continuing my sobriety, and passing the UAs that are now most likely going to be ordered upon me. If like every 60, like a step program, like every 60 days, or 90 days, as long as I'm still passing my UAs, because I get one extra day. So that would be right, because I think his main concern was all at one time, 50-50 would be kind of detrimental to my sobriety, is what he said, I'm pretty sure. So every 90 days of me continuing to prove that I'm sober, by the time she's 3, I think it would be like 3 or 4 months before she's 3, would be 50-50 for me, as long as I'm continuing my stuff. I wondered if he would be open to that as well.
Well, I'm open to all suggestions. My main issue with the 50-50 right now was not that would jeopardize your sobriety, but due to Nora's mental and physical development, that she is very bonded with Megan at this point, and she is reintegrating herself into your life. And I think the current parenting plan is adequate for the next couple of years. When she's a little older and has been around you a lot more, then I would be open to a gradual integration of the 50-50, or actually just go straight into the 50-50. But as long as all the conditions are met and it's safe for Nora and she's bonding appropriately, I'm open to most anything.
Anything else?
That's it.
Okay. Thank you, Mr. Lawrence. I appreciate your input. We'll see everybody on September 4th, and just make sure when you're submitting your declarations, the information for that hearing, that you supply a copy to the other side and also to the guardian ad litem and to the court.
All right, thank you.
Great. Thanks all.
Thank you, Honor.
Thank you.
Earlier, Ms. Holder, I called the case, and your assistant or colleague kindly let us know you're in a different matter in Clark County. And while you weren't here, I talked to Mr. Jensen just a bit, and I indicated that I thought we were there today for a motion for a hair follicle test, his motion. And he indicated that that we were also here to talk about the parenting plan. He said that he submitted a declaration in support of his version of the parenting plan. I told him I hadn't received it yet. He indicated he filed it on Friday, I think. And I indicated that there's sometimes a lag time, especially with the holiday on Monday. So I had not yet read it. And so at that point, we basically took a break, and now you're here. So my understanding from our last hearing is that the parties were going to be submitting declarations in support of their respective positions on the parenting plan. I haven't seen anything filed since. Mr. Jensen did file, but I haven't seen it yet. But I haven't seen anything filed by either party since that last hearing on the 14th of August. So that led me to believe that we were here simply for his motion for the hair follicle test. Ms. Holder, what's your take?
Your Honor, I did receive Mr. Jensen's paperwork for his declaration in support of his motion for hair follicle test. As far as submitting anything for the parenting plan, my client had already filed everything that we already need, and we are happy to stand on those pleadings and adjudicate the case based on what we have already filed. I did not believe it was necessary to bill my client for any unnecessary expenses other than what had already been covered. And I am happy to defend against Mr. Jensen's motion for the hair follicle testing based on what we have already filed before the court.
Thanks. So let me touch base with the parties then. As far as addressing the parenting plan and having consideration of Mr. Jensen's declaration, are the parties available next week?
Yes.
Okay, Ms. Holder.
Yes, Your Honor, but we're going to run into the same issue. The case I was just in has also had a set over to next week, so I am happy to appear, but I might be a little late again.
Okay. Mr. Lawrence, on your calendar, September 11th, are you available?
Yes, Your Honor.
All right, let me just confirm one item on my end. All right, sounds like everyone is available. So we'll set the parenting plan issue over to September 11th at 9 a.m. and we'll review it at that date. Then that takes us to Mr. Jensen's motion for hair follicle testing of Ms. Rhodes. Mr. Jensen, go ahead and tell me why you want that and why you think that's important.
Well, I just know Megan, and I know that when she's single, she tends to party a lot. I submitted the GAO report, which I thought was enough from her case with Thomas Bailey, and it said that both parties had substance abuse issues. Then Ms. Holder said that they wanted to look further into the GAO report. She did submit a hair follicle test though to me from June, which is a while ago. I've been trying to get one since we started this thing, or since I took one. And so I don't know why they didn't tell me that they had already did one and made me do all this work, but I mean, here we are.
So I reviewed the hair follicle test, I think it was from June 7th.
Yes.
So with that having been submitted, are you still interested in a hair
I would like
follicle?
another one, yes, because that was, 4 months ago. I'm willing to take another one too as well if she wants to contest that. But
And the basis for requesting is that you indicated that when she's single, she tends to party a lot, and they're
well, yes, and me and her both had substance abuse issues together. The difference is I went to treatment. She had been pregnant for going on 2 years almost. She had our daughter Nora, who we're here with now, and she was pregnant again with one of our daughters that she had lost, Ruby. So she didn't party, and it was a problem that I kept partying. So I went to rehab to better myself. She was pregnant, but.
So what you're saying is that you went to rehab and then she stopped because she was pregnant?
Yes.
Okay. And then is your concern that now that she's not pregnant, then there's not maybe that wall or barrier to not using?
Correct.
Okay. Anything else on that motion?
That's it, sir.
Ms. Holder?
Yes, Your Honor. As far as Mr. Jensen's motion, it was basically just a statement and asking for a hair follicle test. And as he just admitted on the record, that has already happened on June 7th. My client has never been ordered to take a hair follicle test. She did that completely voluntarily. Even Keith Lawrence did not recommend that she take a hair follicle test. She's gone above and beyond in what she needed to do to provide the court with documented evidence that she does not have a substance abuse problem. As far as Mr. Jensen's allegations go, that is all they are. They are allegations based on what he has believed and what he has perceived. And he has not submitted any documented evidence himself that there's a problem. No text messages, no third-party statements, no videos, nothing of her having a substance abuse issue. Then he goes on the record today and also says that, she was pregnant with their child, Nora, who's at issue in this case. And then there was another pregnancy. And during that time, because she was pregnant, she was no longer partying and using drugs. And so that's at least a documented period of 2 years where she has not used any kind of drugs, if in fact she had a substance abuse issue at all. Did Your Honor have a chance to read the GAO report that was filed in the other case with Thomas Bailey?
That was the one that Mr. Jensen filed with his motion?
That is correct, Your Honor.
I glanced over it. I didn't spend a lot of time on it.
Yes, Your Honor. And if I may, I believe the reason that you did not see a need to spend a lot of time on it is there was just not a lot of substance there. Again, no documented evidence of my client having a documented substance abuse issue. My client contends that some of the statements that are made in there, such as her meeting her former significant other at AA, are not true. They met as high school sweethearts. Again, my client has gone above and beyond. She did a hair follicle test that came back negative in June. Hair follicle tests, as we know, are indicative of about 90 days of behavior and of activity. And so if she was to take another hair follicle test today, that would prove that she was not having a substance abuse problem for another 90 days, which then adds on to the 2 years that Mr. Jensen has alleged that she does not have a substance abuse problem. So if the math adds up, that would indicate for about 3 years now, she has not had a substance abuse problem. And she has not been in rehab. Mr. Jensen has, which is why he was ordered to take a hair follicle test and why he was recommended to take a hair follicle test in UAs, which is why, if we will get to next week on the parenting plan, there's not litigating that issue now, but 191 factors would be appropriate. 191 factors have never been appropriate for my client. And again, she's gone above and beyond. She's proven, quite frankly, beyond a shadow of a doubt, which is not even a standard she needs to prove in this court, that she does not have a substance abuse problem. All the allegations against her are baseless and just that, allegations with no proof.
Thank you, Ms. Holder. Can I ask you a question on the hair follicle test that was accomplished on June 7th? It was negative for the 5 listed items. It was positive for ETG or alcohol. So my question with that is that, sometimes sobriety is an ebb and flow. Sometimes people stop using maybe the harder drugs and turn to alcohol, and then that's abused. So there's concerns that, if a person's sober, and if you're not, and if you're still using alcohol, then you're not sober. And I think the general idea is that you're still at risk of use of drugs if you're still using alcohol, because that's generally a nice, easy way to slide in. You get drunk and you call your friend, and then all of a sudden you're smoking meth or take a line of cocaine. So
That was also my concern, is she failed for alcoholism.
So Ms.
Yes.
Holder, can you address that?
If I may. There has been no documented history of my client having a substance abuse problem, which is normally why a hair follicle test or a UA would be issued. She has not had a DUI. She has not had a problem with the law. Mr. Jensen has not put any evidence forward that she was in inpatient or outpatient rehab for alcohol addiction. It would be, quite frankly, bad public policy to just make people take UAs and hair follicle tests for the allegation that they are law-abiding citizens occasionally having alcohol. Again, he has not put forward any substantive evidence to suggest that she has a substance abuse issue and puts the child at risk or is unable to perform her parenting duties. These are all things that he has alleged he had seen during the course of their relationship. They are no longer together. And during the time that they were together, if he had these concerns, he could have at least provided a shred of documentary evidence, a picture, a text, something, and he put forward nothing, just his own words on paper that she has a problem. But again, Mr. Lawrence did not recommend that she get a UA or a hair follicle. And so I do not believe the court should ask that she has one or take a hair follicle test when she has already done it.
I was looking at Tina Day's report from January of 2019 there, and this is included within Mr. Jensen's motion. It says both parents should be restricted for being under the influence of alcohol/marijuana or any illegal substance during the residential time. Standard UA/hair follicle testing should be included for both parents due to their history and impact on the child. Could you address that in relationship to no history of substance use concerns?
Yes, Your Honor. As far as that GAL report goes, that came from 2019. That was an ongoing case. The GAL report made those recommendations because, again, I believe those allegations had been made, and out of an abundance of caution, it is normal for GALs to make those kind of recommendations. As far as I'm aware in reviewing the record, and I could be wrong, but as far as my review of the record goes, I do not see where my client has had to give up any kind of custody or residential time because of a negative UA or a substance abuse issue. It is quite common that when we have one case and it kind of bleeds over into the next case, when we are dealing with children, that GALs are going to make different findings and different reports. And sometimes a GAL report is initially going to make a more harsh recommendation out of an abundance of caution. But again, upon reviewing this, and Mr. Lawrence has had time to review it, and we haven't heard from him on the GAL report what his recommendation is, there is still no documented history that Mr. Jensen has provided that has to do with the time that they were together for the allegations that he is currently making when it has to do with Nora.
Thank you. Mr. Lawrence?
Your Honor, I had a chance to review Ms. Day's guarding the litem report dealing with Megan Rhodes and Thomas Bailey. And I think that the reason that the GAL recommended potentially a hair follicle exam was due to the fact that Megan did admit to her that she did have, or at least use substances, but she indicated that was like 2 years prior to the investigation of Miss Day. And so there had been an admitted history, but it was like in 2017. And I have not come across anything that would indicate that substances have played a role in any way in interfering with Ms. Rhodes' ability to parent since that time.
Thank you, Mr. Lawrence. Mr. Jensen, your rebuttal.
I mean, like she said, I don't have any evidence, or I haven't submitted any evidence, but she just said that she admitted having an issue previous. But like you said, it's a slippery roller coaster or slippery slide. So drinking could lead to other things, and you know.
Okay. All right. Thank you. All right. So with regard to the motion, it sounds like in the past that there has been some admitted history. Probably it sounds like from 2017. Mr. Jensen indicates that his knowledge of Ms. Rhodes is that when she's not paired up with somebody, she tends to party. There's the former test that was done in June of 2024 that was negative for all illicit substances, but it was positive for alcohol. There's an indication that during the pregnancies that she was refrained from using. And so at this point, there's, at least from my view, certainly there's concerns for slipping back into old habits. People that have had substance use issues in the past, they have to be ever vigilant and just on top of things and checking themselves regularly. Otherwise, it can sneak up and overtake one's life. At this point, there's I think I tend to agree with Ms. Holder. There's no documented SUD issues. While on the one hand, if she were to take another hair follicle test, that kind of really kind of seals the deal, at least for 3 months or 6 months, that, you know, she's again showing that she's refrained from those. On one hand, that may be a real positive, powerful statement for Ms. Holder's client. And on the other hand, it's kind of the power of the state intruding into another person's life without a significant documented history, a recent history of that issue. So at this point, I'm going to refrain and deny the motion. Certainly, if Mr. Jensen becomes aware of any concerns, he can submit a new motion related to any new information that he has. So I'll deny that motion for on to today's docket. Any other items, Mr. Jensen? No. All right. Ms. Holder, Mr. Lawrence, anything else?
No, Your Honor.
Okay, so I think we're coming back. We indicated on the 17th or the 11th. We already said it, right?
11th.
The 11th. Okay, we'll be back next week then.
Thank you.
Very good. We'll see everybody then.
Thank you, Your Honor.
And we'll double check with Ms. Holder. Ms. Holder, are you on the line? I see Mr. Lawrence is on the line. Welcome, Mr. Lawrence.
Thank you.
So this was on the motion related to the temporary parenting plan. Has anybody, was Ms. Holder, I didn't notice if Ms. Holder was earlier on the call. Oh, so,
Your Honor, I read a chat indicating that she was bouncing back and forth with Clark County.
okay. So she very well may be, yeah, it looks like, oh, somebody said she is still in the Clark County Court right now. All right. Mr. Jensen, do you mind? Appreciate it. We'll call you as soon as we can. Are you on the line? And or Ms. Holder?
I am on the line, Your Honor. Ms. Holder had mentioned last week that she was going to be late today.
Okay. And Mr. Lawrence is joining us again.
What? Excuse me, Your Honor.
Yes, Mr. Lawrence?
Oh, I thought you asked me a question.
Oh, I was just acknowledging your presence again. I see that there's a colleague of Ms. Holder who indicates that she's still in Clark County. We'll give it another shot. Thanks.
Thank you, Your Honor.
See that Mr. Jensen is present. Mr. Lawrence is present. Ms. Rhodes, are you on the line?
I am on the line, Your Honor.
Okay. My understanding of the purpose for our hearing today is to take a look at the temporary parenting plan and establish a temporary parenting plan. Is that the understanding of the parties, Mr. Jensen?
Yeah, sure.
Okay, Ms. Rhodes?
Yes.
And Mr. Lawrence?
Yes, Your Honor.
Very good. All right. Well, maybe what we could do, if it's okay with the parties, I'll hear from Mr. Lawrence initially, and then we'll hear from Ms. Rhodes and then Mr. Jensen, and if you're okay going in that order. Great. Mr. Lawrence?
Your Honor, I submitted my report on June the 21st of this year. It contains 12 recommendations, and I would encourage the court to follow those recommendations. I understand that Mr. Jensen is asking for a 50-50 arrangement on the visitation. He's also asking that Megan Rhodes undergo a hair follicle exam. With regards to the 50-50 arrangement, Nora is only a year old, and I think to do that at this time is probably a little difficult on her. I would suggest the court allow Nora to reach at least the age of 3 before imposing anything like that, and which is going to create a situation where Mr. Jensen is probably going to request a second daycare while she's with him. And Ms. Rhodes, I understand, is in opposition to that. So that's where we are there. With regards to the hair follicle exam, Mr. Jensen was just out of inpatient care at the time that I was appointed to this matter. He wanted visitation with Nora. Ms. Rhodes had some concerns as to what the situation was at his home in Chehalis. And Mr. Jensen and his girlfriend, Ms. York, both voluntarily consented to a hair follicle exam so we could see what his history had been over the last 90 days. Now, he is indicating that when they were together, he and Megan, that they partied a lot, and therefore he would like to have a hair follicle exam. I did look at the GAL report submitted by Tina Day, which was done in, I believe, January of 2019. And in that report, it indicated that Ms. Rhodes had indicated that she did party quite a bit, but that was a couple of years ago, if I remember the quote. So that would have been closer to 2017. And there's no allegation since of her abusing any drugs or alcohol, and certainly nothing that would impair her ability to parent. So I would recommend against that at this point, unless Mr. Jensen can provide some form of evidence.
Thank you, Mr. Lawrence. All right, we'll hear from Ms. Rhodes, or pardon me, Ms. Holder, on her behalf. Go ahead, Ms. Holder.
All right, thank you, Your Honor. We propose that the court adopt Ms. Rhodes' parenting plan that she submitted to the court back in August of 2013, or sorry, August 13th of this year. The proposed parenting plan takes into consideration the GAL recommendations that Mr. Lawrence put into his report. Additionally, a few other things were added, and I would like to go over those, specifically sections 3 and 4. Sections 3B lists that there is, or the proposal lists that there is a substance abuse issue. We believe it would be fair and appropriate for a 3B finding here due to Mr. Jensen's recent stay in inpatient treatment and admitted use and abuse of controlled substances, including alcohol. He does have a long-term problem with it. And again, this is a temporary order. And should he be able to basically prove himself over the course of time through the pendency of the litigation until final orders, it would be appropriate for a 3B finding. Due to a finding for a 191 factor for substance abuse, we would ask that there be limitations placed on Mr. Jensen. That is detailed for section 4 limitations, including that he used SoberLink in order to monitor his alcohol usage prior to visits with the child. If at any point in time he does test positive for alcohol or other controlled substances, his visitations would never be suspended. They would revert back to professional supervised visits until a professional supervisor recommends that he go back to unsupervised. So at no point in time would he ever forfeit his residential time with his daughter due to his addiction. This is merely a way to monitor, to make sure that he is on track and he is the healthiest version of himself to be the best father that he can be. We would ask that remain in place during the pendency of the litigation up until final orders. And that could always change if he does really well, and he can always petition the court for that. When it comes to decision-making, we have gone with joint decision-making, which again is at the recommendation of Mr. Lawrence. Ms. Rhodes being listed as the custodian again for the GAL recommendations. For the school schedule, she is only 2 years old. We are also going with Mr. Lawrence's recommendations here that the schedule be the same as it is right now. We go with the status quo, which is that Mr. Jensen gets Nora every Thursday at 5 p.m. until he drops the child off on Monday morning, and that is every I believe that is supposed to say every other week, as that is what is currently. And so I would ask that the court strike out every week and insert it does say every other Thursday. So that would be remaining. That's correct. That would remain the status quo. Once she turns 3 years old, at the recommendation of Mr. Lawrence, we could propose it would move to a week on, week off schedule, so long as the parties live within a 20-minute drive of her daycare. And that is to ensure that she is only enrolled in one daycare. That's included in section 14, and I'll get to that in a moment. But if we are still in temporary orders at the time she starts kindergarten, which I hope not, because that's 3 years from now. I hope we have a final plan by then. But in case we don't, this also would account for a week on, week off schedule if Nora lives in the same school district or within a 20-minute drive of the school. And that is to maintain stability for her through the parent schedules, to make sure that she's only going to one school. She's going to a school that's not too far away. Whenever you have children have to commute long distances. The longer distance for a commute, the more chances that the child is going to be tardy or miss out on school. And so we don't want that to happen. So we would ask that for the school schedule, it be in place for now that she is 2 years old. An additional step up to week on, week off when she is 3, provided that she is going to be in the same daycare. And then if we are still in temporary orders by the time she is 5 years old, again, another week on, week off schedule, provided that she is still in the same school district or within 20-minute drive of the school. Summer schedule would stay the same. And then once she goes to kindergarten, again, if we're still in temporary orders 3 years from now, then it's a week on, week off, and they can agree on a halfway location. Holiday schedule, we believe this is pretty fair and accurate for both parties. It does switch off between Father's Day, Mother's Day. Mother would get child on Mother's Day, father would get child on Father's Day. There are set times for that, so it is only for for the full day. Labor Day weekend and Memorial Day weekend are alternating. Make sure that each parent has the child at least one of those weekends, as it's only fair. The holiday schedule for Thanksgiving, even and odd, Christmas Day and Christmas Eve, even and odd, so it alternates between the parties. Again, we think that's fair. When it comes to the transportation arrangements, the parties live a little further away from each other right now. So just making sure that whoever's going to start their parenting time with the child needs to arrange to have the children picked up. As far as I know right now, the child is being exchanged at the halfway location. And if I don't believe that has changed, I think that would still be appropriate. But we do ask, I'm sorry?
Just a clearing of throat.
Okay, making sure I didn't miss something. Thank you. Making sure that for transportation arrangements, anybody driving the child has valid driver's license and information available, and that if they are prompted, they can provide that. Any failure to provide that would, it wouldn't necessarily forfeit the time. It would just kind of put a pause on things until an appropriate qualified driver is available. However, if one is not able to be provided, or there is this amount of time that is taken to get a qualified driver, no makeup time is going to be granted for that. When it comes to section 14, this does include the provisions down towards the end that the child cannot be exposed to alcohol by anyone during Christensen's residential time, if this court adopts this plan, would be the one with 191 factors regarding alcohol. Number 12 is the child should not have contact with anybody with a conviction for a sex offense, nor shall the child have contact with anyone who has been accused of credible allegations concerning a sex offense. We went over this a little bit at length with Mr. Lawrence per his recommendations that the child shall not have any contact with John Pittman. This goes a little bit further, that the child shall not have any contact with anybody for a conviction with a sex offense. It would be up to the parents to do their due diligence to make sure that the child is not in contact with anybody with a sex offense. Now, the second part of not have contact with anyone who has been accused of credible allegations, that would be up for the court to decide if it is a credible allegation. But we believe it's in the best interest of the child that if either parent says to the other parent, hey, this person that you're around, I found out that there are some allegations against them and they're pretty credible, we would hope the parties would agree that, yeah, my child should not be around this person. But if there is disagreement about that, they are welcome to bring the issue before the court for credible allegations and provide evidence of what makes an allegation credible. That seems to have been an issue here, where allegations were being posed by both sides without any credible evidence. So that would be up to the court to decide what in fact is credible evidence. Section 14, number 14, the child shall only be enrolled in one daycare at a time, and her daycare shall not be changed unless there is agreement by the parties in writing. This would be appropriate because of the distance the parties live between each other. It is important that she has stability for as much as we can provide this child. And so one daycare only having contact with the same people day in, day out to facilitate that consistency would be appropriate. There is always the concern that a parent might switch daycare without notice of the other parent. There is joint decision making, so that is an increased likelihood that could happen in a case like this. So we would just ask that the court put into effect section 14, number 14, that she's just enrolled in one school at a time. If the parties can agree that they want to switch, then they need to do so in writing. For section 14, number 15, that goes for an overnight of longer if for right of first refusal, for lack of a better term, that it's giving the opportunity for the parents to spend as much time with this child as possible, except if the child's scheduled to stay with her maternal grandmother, as it's pretty common that she already does that. And then the last part is section 14, number 16. If the parties are going to go out of town, for an overnight, they just need to provide the other side with the names and birth dates of all people who are going to be staying with them and the child, and they need to provide that information no less than 7 days prior to the planned trip. This is simply so that both parties have the opportunity to run a background check on anybody who is going to be around the child for an overnight. This case with the allegations regarding John Pittman, it was entirely appropriate that the parents, if they're taking the child out of town and the child is going to be around someone for an overnight, both parents should be entitled to know who's going to be around their child and have the opportunity to do a background check on that person to make sure that person's good, which goes toward the no person with credible allegations or sex offense. That kind of dovetails into that provision. If that information is not provided, then the person would forfeit that time and the trip with the child. It is important in this case, and for the allegations that have been made, that this child is protected and both parties know who their child is around, especially on overnight trips. We would ask that the court enter this because it's appropriate for the child based on the GAL's recommendations, based on the history between the parties, based on the parties' individual histories regarding substance abuse. Regarding Mr. Jensen's proposal that hair follicle tests be done on Ms. Rhodes, that issue was addressed last week when the court denied that motion. It would be appropriate to put into a parenting plan after the court already denied a motion. And as far as the request that it be 50-50 now, that is inappropriate. The child is under the age of 3. We can go for another year of the schedule that's in place until she really develops object permanence and has some stability. And this parenting plan provides for a 50-50 split when she turns 3, if the situation is appropriate. And for those reasons, we would ask the court adopt this parenting plan.
Thank you, Ms. Holder. Mr. Jensen.
I just had a couple questions. Well, first of all, I do want 50-50. I feel like she's at the age right now. She is almost 2. She gets so excited when she sees my house, or even when I'm getting off the exit, you know, she knows that we're at my house. I feel it's fair for bonding and, like, you know, but questions about hers was, it says in number 14, the 13th one was nobody's allowed to drink while only in my residential time. I feel like that's going to be in the parenting plan. It should be both parties. Number 15, right of first refusal. I feel that her grandmother can come see her whenever she wants. That shouldn't take away if, you know, I should get the first right of refusal. So her grandma could come see her, or Megan could take her to her grandmother, but staying over the night, I would rather have her than her mom. And then clarification on the 16th one where it says overnight, like, so is that like camping? Is that like if I go to a wedding, do I need to specify who everybody is at this wedding? Or those are some of my questions. For the sober link, I voluntarily checked myself into rehab, so I get that it's a concern, but to have all these stipulations put on me and only me is, I feel, unfair, considering I'm trying to better myself, and like SoberLink having to blow before I go pick up my daughter or anything. UAs is one thing, but to do this every single time, who's paying for it, first of all? Some of my concerns.
All right, thank you. All right, I appreciate the patience and the information that all parties have shared with the court. The mother will be designated as the primary custodial parent. I do think a 50-50 plan at this point would be premature, but I'm fine with the 50-50 at age 3. I think that object permanence that Ms. Holder mentioned, I think that's important. So that means that father's time now until a child is 3 would be Thursday at 5 p.m. until Monday, dropping off at daycare on that alternating basis. As far as 191 factors or limitations, I think it's important to look at that language under the proposed language under 3B as in Bravo. It says Chris Jensen has a long-term problem with drugs, alcohol, or other substances. I think that's true. The second part is that it gets in the way of his or her ability to parent. I don't think that's currently true. So I'm not going to impose the limitation under 3B. So there will not be a limitation there. As far as the hair follicle request of Ms. Rhodes, I think that there's insufficient showing that there's concerns to warrant that's under hold off. Yeah, okay. And then as far as the section 4, where it's talking about the sober link, I'm going to not grant that as far as the sober link. I think there's a provision that Ms. Rhodes can request a UA within a certain period of time, and it would be kind of loser pay. So if Ms. Rhodes requests it and Mr. Jensen provides the UA and it's negative, meaning there's no alcohol therein, then she just eats the cost. If it comes back that Mr. Jensen tests positive, or it's test positive for alcohol, then he would have to repay for that cost. I think that's a sufficient provision to provide protection to the child and not require the sober link. So although require the UAs can be done, the random UAs can be done. I think the prohibition of 8 hours of no consumption of alcohol prior to a visit, I think that's fine, and that would apply to Mr. Jensen. Do you have any issues with that?
What was that? Sorry.
Not drinking any alcohol 8 hours prior to any visit?
For both parties though, right?
Well, I'll get to that in a second.
Sorry.
Just 8 hours prior to your
Oh,
time with her.
Yeah.
Okay, so I'll impose that. As far as alcohol consumption, it sounds like both parties have had issues with alcohol in the past. So both parties are prohibited from consuming alcohol during their residential time. So no party will consume alcohol while they have the child with them. Mr. Jensen, I think last time you said it's your intent to continue to attend self-help meetings, sober support meetings like AA and the like.
Yes, Your Honor. I have an hour drive home, so usually I do like a Zoom meeting on the way
To and from.
or from home to home.
How do they sign your meeting slips?
They don't. I'm
Okay.
doing it all on my own, so I never needed a slip. I never asked.
Okay.
Like I said, I checked myself involuntarily. I was doing IOP for a while, but it's full of everybody with DUI and nobody really wants to help. And I feel like the place that I was at least they were like catering to that. So I didn't really learn anything that new that I didn't learn in rehab. So I figured AA was the best way to go for my sobriety.
Okay. So you'll need to figure out a way to show proof of attendance at those meetings. So I don't know, you'll have to work with the meeting organizer or whoever's chairing the meeting to provide proof that they can, mark it off to show that you're attending. And Ms. Rhodes can request that at any time, and you'll need to provide that you're attending those meetings regularly. I think that's important because that's going to provide that sober web and that extra vigilance that I think all of us need when returning to sobriety.
Do I just keep a log of every time I go, and then whenever she asks, just give her the whole stack of papers or whatever?
Right.
All right.
Right. Mr. Pittman, we talked about him. He's not to have any contact with the child whatsoever in any place, time, or context. Joint decision-making is approved. I think that's fine. The holiday schedule that's been presented seems to be pretty even. So I'm fine with adopting the holiday schedule proposed by Ms. Holder. The exchange location, it'll be a halfway location between the parties' residences. The person who's starting their residential time with the child will be the one doing doing the pickup, but it's at that halfway location. So you both go there and exchange the child. Valid driver's license insurance is important when you're transporting the child, so that's required. The summer, I'm fine with the summer proposal where each party has 2 non-consecutive weeks for vacation. So that means 2 non-consecutive weeks, yeah. At age 3, I'm fine with the adoption of the week on, week off. And that's conditioned upon no further issues with Mr. Pittman and that Mr. Rhodes continues to be compliant with his sobriety and recovery, meaning meeting slips and continuing to not have any issues.
Mr. Jensen.
Sorry.
Yeah.
Sorry, Mr. Jensen. That's correct. Once we get to that 3-year status, the daycare seems to be of concern to both parties. If it's going to be week on, week off, the parties very well may be living further than 20 minutes. And I think that's unreasonable to require the parties to drive that extra distance. So 2 daycares when the child turns age 3 is permissible. They'll be with each parent. They'll attend whatever daycare that parent cares to enroll the child in. The romantic partners, well, there's the restriction on no introduction of registered sex offenders to the child. I think that's appropriate. Then we take a look at the proposed language in paragraph or section 14, paragraph numbered. Oh, where is that? Ms. Holder, if you can point me to, there it is, 12. It says the child shall have no contact with anyone with a conviction for a sex offense. I'm fine with that language. That goes on to say, nor shall the child have contact with anyone who has been accused of credible allegations concerning a sex offense. I think that's common sense. And so I'm going to strike the rest of that. So where it says nor shall to the end of that paragraph will be stricken. So the child shall have no contact with anyone with a conviction for a sex offense.
Well, you would think it would be common sense, but Ms. Rhodes did do that. So
yeah. So you're wanting to have that in there.
Yes.
Okay. And Ms. Holder, you're wanting to have that in there also, correct?
I think it would be appropriate for both parties.
Okay. We'll keep 12 as is. We'll keep it fully intact. Then the 13, I mentioned paragraph number 13, the child shall not be exposed by alcohol by anyone during both parties' residential time. So that should be amended. The daycare on 14, I mentioned what my ruling is on that. When it comes to the age 3 and 50-50, they can each employ their own daycare. Then on 15, I am fine with the first portion of that until it gets to the word unless. So my concern there is that at any time where the mother's not available, she's going to turn to grandma and Mr. Jensen is not going to have time with the child. I think that's a pretty reasonable interpretation of that. So I'm striking the language that says unless the child is scheduled to stay with the maternal grandmother. That in a way that's promoting the grandmothers or grandparents' rights above that of a parent, and so I'll strike that language. Under 16, 16 seems pretty invasive to me. About the overnight visits. There's a degree of trust that each parent should have in the other, that they're going to, I think, providing a location, you know, in today's world with so much connectivity, providing location, you know, if something were to happen, right? That's the big concern. It's like, if something happens, how do we get in touch with this person? How do we get in touch with the other parent? That's important. Having the names and birthdays of all the persons who will be staying with the child. I think that's too much, and so I'm not gonna grant that. I'll exclude all the rest of that paragraph. So it says if the parent plans to take the child out of town overnight, he or she must provide the locations where where they'll be taking the child. Period. The rest of that will be stricken. Then there was, I believe there was a recommendation. I'm not sure where it came from regarding Family Wizard. Was that from you, Mr. Lawrence?
I had talked to them about it, and it was number 11 in my recommendations.
Okay. So I'm going to adopt that. The parties will use Family Wizard. That way parties can communicate, and then there's a third party that controls the data and the information that exchanged between the parties. So both parties have to sign up for our Family Wizard.
Family Wizard.
So it's called our OUR Family Wizard. It's a communication app that allows for exchange of documents. It allows for text messages, and everything's recorded and saved. Each individual have to kind of sign up for it on their own, and there's a monthly surcharge for it. I don't think it's overly cost prohibitive, but every little bit does add up. But and then there is a proper request for proper storage of firearms if firearm rights are restored, and I'll require that if parties have firearms, they must be properly locked and secured so the child does not have access to them. I think that let's see. So I think that addresses the issues that the party raised. Any clarifications requested or needed from any party?
Right now. So when Nora's turning 3, we got to bring this back to court?
No, it'll automatically switch to the 50-50.
Okay.
So, and I don't know if we need to specify a day of the schedule change.
Well, her birthday is New Year's Eve, so we could go off the first of the year.
Yeah, it's active on the child's birthday. If the parties, so, you know, looking at 2025, you know, common is the exchange on say a Friday or a Saturday. So Friday usually after school, or Friday in the afternoon would be the exchange time. If there's any concerns with that, I'd hear from the parties. Any objections to Friday afternoon for the exchange to occur?
Neither one of us work on Thursday. I think that's why we picked Thursday. Or neither one of us work on Fridays. I think that's why we picked Thursday after work.
That's fine. If you want to do Thursdays, I'm okay. If
We have
that's the
daycare, we
exchange
could
day.
drop her off. She can pick her back up from daycare.
Ms. Holder?
I am not sure my client is on the line if she would like to fill that in for the court.
Sure. Ms. Rhodes, if we're looking at age 3, when Nora reaches age 3, having the exchange for the 50-50 plan occur on Thursday afternoons, evenings.
That would be fine for me.
Okay. All right. So it'll be Thursday will be the exchange date for when when a child turns 3. Any other questions or clarifications?
I just had one question, Your Honor, on the 3, section 3, the 191 factors. So we are not putting any 191 factors in place.
Correct.
The court had mentioned that Chris Jensen has a long-term with drugs or alcohol, but it does not believe it gets in the way with the ability to parent. So strike section 3.
Correct.
Right. And then the section 4 limitations are loser pays UAs at the discretion of the parties, and then making sure that Mr. Jensen is able to report to Ms. Rhodes his sobriety as far as his AA meetings, or did you want him to also provide that information to the court?
She can request it of him, and he'd have to provide it to her. And if there's any concern, she can bring it to court and bring it to the court's attention.
So just so I'm clear, he does not need to provide that information to the court. He only needs to provide that to Ms. Rhodes if she asks for it.
Correct.
And so on that, how long do I have to do this for? Is it indefinite or until the court orders otherwise?
So this is a temporary parenting plan. So this will be in effect until there's a final parenting plan. And final parenting plan can be achieved either by agreement between the parties or a trial.
Okay.
So sometimes temporary parenting plans, I've seen them go on forever. Parties are fine with it and they don't change anything. Other times parties need to change things. So
So if this goes well for a while, who do I talk to? Do I call Megan and be like, hey, did you make this permanent, and then come back to court and make it permanent?
If so, any litigants in a case can agree to end the case through agreement, and if they come to agreement, great, it ends it. However, if there's not agreement, then the parties could schedule for a trial and get it on a trial track and have it resolved in that fashion.
Thank you.
Ms. Holder or Ms. Lawrence, any additional points of clarification?
I do not have any, Your Honor.
Mr.
I don't
Lamb?
either.
Okay, so then, Ms. Holder, there's a couple of adjustments that were going to be made to that proposed parenting plan. Would you be in a position to make those amendments and then forward a copy to Mr. Jensen for his review? And then we could take a look at setting it on the calendar for a presentation. And if the parties agree, sign off on it. Mr. Jensen, if you feel like Ms. Holder got everything right that I said here today, you can simply sign off on that parenting plan, and then the hearing would be stricken. However, if you feel that she got it wrong and she's doesn't want to change it, then we could come to court, and then the court will make a decision on it.
Okay, yeah.
So we're looking at September 25 for a presentation. That's a Wednesday. I'll ask the parties to check your calendars to see if you're available on that date. Mr. Jensen?
And so if I talk to Amanda and I look through this, everything's good, I do not have to come.
Correct. Yeah, and if you sign off on it, that's way I know that you're okay with it, then you wouldn't have to come.
All right, thank you.
Ms. Holder?
Yes, I believe that I can handle that, and I will work with Mr. Jensen to try to avoid a hearing and try to get everything as accurate as the court has said.
Okay, great.
And the 25th does work.
Okay, we'll set it for September 25, 9 a.m. for the presentation, with the caveat if the parties agree, then don't need to come.
Thank you.
All right, that'll conclude the hearing for today. Thank you both. Ms. Farmer, correct?
Thank you, Your Honor.
Yes.
Okay, welcome to you, Ms. Farmer. I'll ask if Ryan Hicks is on the line. Ryan Hicks? All right, I'm looking in the participant list. I'm not seeing a Ryan. Yeah, let me look under Hicks. Not seeing a Hicks either. Ms. Farmer, we're on today for a pretrial hearing. I just wanted to clarify what the pretrial is generally in preparation for a future event, and the future event in this case is a mandatory settlement conference, not a trial. So a mandatory settlement conference is a time where the parties come together, and there's a judicial officer that kind of does some shuttle diplomacy between the parties to see if there can be grounds for agreement on particular issues, if not all the issues. So that's set to begin. Well, it's set for the week of September 2nd, and on August 27th at 11:30, that's the readiness hearing. On August 27th at 11:30, that would be the time when the specific date during the week of September 2nd would be chosen. So
Okay.
on August 27th, you'll know the particular date for that mandatory settlement conference. It's blocked out for a half of a day. Yeah, I got an update from Jalen yesterday. Yeah.
Okay.
So then it'd be a half day. Then if there's materials that you want to submit for the court to review in preparation for that mandatory settlement conference to address any of the issues that are of importance to you, you'd submit those to the clerk's office to get those to the judicial officer for his or her review.
Okay.
So do you have any questions about kind of what's upcoming or how to prepare for that?
No, but I do have a question. He has not served me his second parenting plan. And he's now living out of state in Oregon. Do I have to do all this again in Oregon too? Or will it just
No, the matter's pending here in the state of Washington. So we're moving forward with the case, and
Okay.
hopefully he will participate in the process. So
Okay, that's all. Thank you.
great. We'll see you on August 27th at 11:30 for the readiness hearing.
Perfect. Thank you.
Thanks. I'll ask if Cherish Morgan's on the line.
I'm here.
Okay, welcome to you, Ms. Morgan. I'll ask if Jonathan Morgan is on the line.
Yes, I'm here.
All right, thank you, Mr. Morgan. Thank you,
Excuse
Ms.
me.
Morgan. All right, thanks for your patience. We truncated your hearing the last time we were here, and we moved it over today. So thanks for your patience today.
Of course.
I've reviewed the pleadings again in preparation for today, and so the issues are property division and associated debt, and also the issue of spousal support. And I just want to double check with the parties if I don't know if you've in between last time we were here and today, if the parties have talked and if there's any agreement on any of the outstanding issues. Ms. Morgan?
No, we have not talked because I have no way to contact Mr. Morgan. He has me blocked on everything.
Okay, all right. So let me just ask Mr. Morgan, maybe we kind of winnow things down here a little bit. So the petition or the request by Ms. Morgan, she's making a request that the 2019 Coachman trailer and the associated debt go to her. Are you in agreement or disagreement with that?
I am in agreement to that. I wanted to mention something last excuse me. Last time we were had this hearing, I was making 18 an hour. I very unsure right now because I just found out yesterday when I went to go sign a time card that the assignment that I was on told my temp agency that to reassign me. I have not heard any other new word of it yet. I will be making contact with my temp agency today about what's going on. So I don't have any work at the moment. So I just wanted to bring that to your attention. So that way you know that I'm not like trying to hide anything or anything like that. I wanted to bring that to your understanding that right now I'm unsure of work at the moment because I don't know what's going on with the assignment that I had and between my temp agency that I'm working through.
Okay, so the notice that you had is that there's some type of reassignment occurring?
Yeah, so I don't know what's really going on at the moment. I gotta call my temp agency and figure out what's going on. I know the tape agency I'm working through is down one person due to some fraternity leave. So I know the one person that I am dealing with is very busy and doesn't have anybody to help her. So I just got to clarify with my temp agency what's going on.
Okay, I appreciate the notice. Thank you. So then you're in agreement with the trailer and the debt going to Ms. Morgan. As far as the Subaru and any associated debt with that, Ms. Morgan's requesting that go to you, Mr. Morgan. Do you agree or disagree with that?
Yes, I fully agree. I'll take the ownership of the Subaru. Along with that, I prefer to not have any contact with her, but I will I will have to have my mom or somebody give her the title so that way she can sign it over. So that way, if I decide to sell the car for any reason, I already have the title signed over and I don't have to go hunt for Cherish to sign the title and have any other issues.
Ms. Morgan, any concerns if the court ordered a third party to act as kind of an intermediary between the parties for any exchanges of titles or cooperation in signing documents?
I was gonna see if there's any way that we could just make him try to refinance or something so I can get my name off of it. So then we won't have to deal with any of that and I won't be reliable if he misses a payment or anything on it.
Well, that's kind of the idea. If a particular item of property is assigned to one party and the associated debt, then the debt would need to be refinanced out of, if it's in both names, it would need to be refinanced into the sole
Yes.
person's name who's responsible for it.
Okay.
So that's why I'm saying if there's any coordination involved with that, then a third party could assist with that, of helping get documents to people and helping be kind of the communicator between the parties.
Yeah, that's fine. I'm okay with his mom.
Okay. Mr.
And
Morgan?
I just wanted to add to that. I will try to get her name removed, but I can't guarantee anything because my credit score is really low. But I will do my best to get her name removed off the title of the Subaru, but I can't guarantee that because as far as I understand, trying to get my name solo on the car, I will have to either somehow come up with a bigger down payment for the car or have someone else sign. But right now I have to kind of get things in order for that. But like I said, I can't guarantee due to my credit score being so low, but I will try my best to get her name removed.
Okay. The Nissan, Ms. Morgan is requesting that go to Mr. Morgan and any associated debt. Do you agree or disagree with that, Mr. Morgan?
Yeah, that's totally fine.
Okay. And then the request that the Visa card ending in 0973 goes to Mr. Morgan. Do you agree or disagree with that?
That should be his.
Yeah, I believe. I'm sorry. I'm trying to remember what card that is, but I'm pretty
Did
sure
you say the
that
last
is
four
mine.
again?
0973.
That's his.
Yeah, that's mine.
What's
So
the
yeah,
balance on that? Do you know, Ms. Morgan?
Could you
for
repeat
my
that?
credit
Sorry.
Yeah,
card,
just the balance on the 0973. So that's just a further identifier.
I will have to check really quick. It will only take me like a second.
Okay. Yeah, double check on that and just look at that. And then I'm just going to kind of go down the line here, just to make sure we're all on the same page.
The balance for my credit card is $498.76.
Ms. Morgan, does that sound like that's the right one on the 0973 account?
Yeah, because I think his maximum was 500. So
Right.
Yeah, it was.
All right. And then Ms. Morgan is requesting that the Visa card that's in, I'm not sure what the card ends in, but that go to her. Ms. Morgan?
yeah, it's my credit card. So yeah.
What are the last?
I don't have the last four because I don't have the card. I just pay on the bill because I'm trying to pay it off, get rid of it.
What's the current balance?
$990.
Okay. Any disagreement, Mr. Morgan, if that debt goes to Ms. Morgan?
No, sir.
The US cellular bill, I understand that there's an ongoing $77 a month service fee payment and the like, and then there's an outstanding bill of $350. Is that accurate, Ms. Morgan, from your vantage point?
Yeah.
Okay. And Mr. Morgan, is that kind of your understanding too with the cell bill?
Yes, but I would like her to sign the US Cellular paper at the store and get her removed off my uh, phone plan and her get on her own.
Ms.
If-
Morgan, any comments on that?
I'm totally fine with paying the monthly service fee, but I do not want to pay the phone and the iPad off because those were gifts from him. So I feel like it's not fair for me to have to pay for those devices.
So so it sounds like you're agreeable to get off the plan and get your own cell plan and then have Mr. Morgan pay I think the outstanding balance of $350, which is the payments on the hardware.
Yeah, I will agree if he pays the payments on all the hardware and I will pay the monthly service fee, like the data and phone calls and text messages.
So what Mr. Morgan's asking is that you be removed from that account. Basically, you get off that cell plan, and you'd have to get your own cell plan. Are you comfortable with that?
Yeah.
Okay. All right. And then, Mr. Morgan, are you comfortable if she gets her own cell plan, she gets off the plan, and then you would be responsible for the hardware payment?
So if she removes herself off my phone if she signs that paper and separates that phone plan, all the hardware and the service goes to her. Like I can't.
If she gets off, it wouldn't, because you'd be the remaining person on the account.
So I would have my own account, but her phone, her tablet, the service and stuff, all goes to her own phone plan. So I wouldn't have, and if I don't have contact with her, I have no way of paying that.
So is there any way that I could just stay on the phone plan? He pays we can go to US Cellular, get something written up. He pays the phones and I just pay him monthly, or I can go to US Cellular myself and pay my service fees.
Well, it sounds like the parties aren't communicating well, and having continued contact and continued joint accounts, I don't think is a good idea. It's going to lead to issues in the future. So my understanding with any type of account, ongoing account, that if it's two people are on the account, one person can be removed, and that the remaining person remains responsible for the cell plan and also for any hardware associated with that. So if Ms. Morgan is removed from the plan, that $77 a month for her share of that plan goes away. And then Mr. Morgan would be responsible for his cell and also any hardware that he has that he's paying on. Does that sound accurate? Does it seem feasible to you, Mr. Morgan?
Yes.
Okay. All right. And then the fiber loan of $100, the proposal is that debt goes to Mr. Morgan. Mr. Morgan, do you have any disagreement with that?
Um.
Go ahead.
So I'm sorry, I'm trying to process it. So which loan is
Can I
this?
butt in real quick?
I have a note that it's the fiber federal loan of $100.
Well, the fiber loan was I can pull it up. There's $1,220 left, but the payment every month is $100.
Oh, okay. Mr.
And
Morgan,
that loan we took out together.
what's your position on that?
As far as I understood, so that fiber loan I don't really agree with, because that because due to my credit score, I wasn't able, at that time I was not able to. Yeah, I signed the paper, but I don't have any account for that loan and partial of my name, so there's no way of me even having to pay that.
What was the purpose of the loan?
It was to get our cats fixed, and we were going to be moving.
Okay.
And then just some other personal things we needed. And I can also get from the bank that has his name on the loan. I can get a printout of that.
Okay.
And he did cite it because it doesn't show on his bank account that the loan, they have it on mine. Just like the Subaru is in both of our names, but it's not on my bank account. On my thing, it's on his.
So this fiber loan, is it a joint account or a
No.
sole account? Whose name is it in?
It's in both of ours.
Okay, that's when I say a joint account, that's what I mean, when both names.
Yeah.
Okay. Right.
Uh, can
So
can I
let's go down the
say-
line. There's a lot of items and we've got to move quickly. So last comment, Mr. Morgan, on the loan.
So, I do not have that paper showing that I signed for that paper for me. The only loan paper I had that was signed by me was for a $3,000 loan. Uh-huh. A $300 loan. I'm sorry. A $300 loan. I got my numbers mixed up. A $300 loan, not that loan. I that was the only paper I signed for a loan was a $300 loan.
Is
And I
there,
have that paper somewhere in front of me. It's bundled up in a stack.
I have that paper right here, and I know you want to move off of this, Your Honor, but that loan, yes, we did add $300 onto it because we had paid some off and onto it. And if Jonathan wants to communicate with me after this, I can explain it more to him and he will probably remember. But I don't see that happening.
Okay. All right.
I
Thank
just
you.
don't want to keep you here on that.
Yeah, nor do the rest of the people that are waiting. So the storage unit, the proposal there that Ms. Morgan is proposing, and I'll ask Mr. Morgan his position on this, is that there's an outstanding monthly bill around about $260. And I felt a note here, Ms. Morgan, what's your proposal on that?
I feel he should pay half of it.
Okay, Mr. Morgan, what's your position?
Yeah, I do have stuff in there. Like I said, last week, I only want a few things out of there. Other than that, she can sell the rest of my stuff. Um, so that way I don't have I don't have anything in there that's really worth value to me or sentimental value to me. So honestly, a lot of things she can just sell all of it, get rid of it. That way my stuff's not in there. Like I said, there's only a few things I want out of there.
Can you
So
get your items out by a date certain, like say in maybe in 2 weeks?
if she can get my stuff out in the 2 weeks and give them to my mom, and then I can pick them up from my mom, that would be
You'd be
amazing.
responsible. You'd be responsible for collecting your own items, not her.
If he
Well-
can, if he can agree and message me after this and we can pick a date that his mom can be there. So it could be me, his mom, and I'll have my aunt be there. So we each have one person with us. So just us four go in there and get stuff out of storage. I would be okay with that.
Mr. Morgan?
I can agree to it. I just don't want any issues.
No
That's it.
issues, civil.
All right. So, so as far as the storage unit, okay, I appreciate everybody's input on that. And then car insurance, once the cars are divided up, each party has their own vehicles. Are the parties agreeable that each party would then be responsible for the cars that are in their own possession? Ms. Morgan,
Yes.
Mr. Morgan.
Yes, I do agree to that. I just want to note that I did get a letter from our insurance that the cars were already separated long before our first court date.
Okay. Meaning the car insurance covering each of them?
Yes, so she from that letter from the car insurance, I don't know if you have that in front of you, Judge. She already took her Jeep and and the coachman travel trailer and already separated it long before the court date. So everything's already separated. We just had to wait until the final court
Ms. Morgan?
for the final ruling.
So with that, all I did is because I knew he was not being able to make his payments and I need car insurance for my job. So all I did is I called them and they just switched. The policies are all together still because legally they can't separate it until we're divorced. I pay my $160 a month and he pays his bill a month. That's all that's separated by that, but everything is still pretty much together.
Okay. All right. Thank you. Let's move lastly with the 2015 Jeep. Ms. Morgan is proposing that she be awarded that vehicle. What's your position, Mr. Morgan?
Yeah, that's all her. She only has her name on it. Like obviously she knows, she has her name on it. I don't have my name on it. So that's all on her.
Okay. All right. And then let's move to the request for spousal support. Ms. Morgan, go ahead and tell me why you feel spousal support is appropriate, and then we'll hear from Mr. Morgan.
It was just to help pay all of this part of storage, pretty much just to keep it short, all of the bills to pay his half that wasn't being paid and just to help me literally live in life.
Okay.
Because I am partially disabled and I'm fighting with Social Security at the moment. I just had a appointment yesterday with them and I have another one Friday to get put back on Social Security, and I'm still working part-time, and now I have a broken ankle.
Okay. All right. And then the parties, you lived together for roughly 4 years. Is that accurate, Ms. Morgan?
Yes, I have the actual date. I have dates if you would like dates again.
It's okay. I think a general idea of 4 years, so that I think that's appropriate. Okay. And then Mr. Morgan, what's your vantage point regarding the spousal support?
Um, so I'm trying to put this without doing too much confidentiality, due to the company. So I did get word that, there was, so I used to be a caregiver back quite a few years ago. I do not feel that spousal support I need to do spousal support only because when I was getting certified as a caregiver, I was able to work a full 40-hour plus week and still get certified through the company I was through. So I do not feel that spousal support is needed because I know and I've thought about going back to caregiving and I've looked up jobs for there is opportunity to work more than 40 hours plus, depending on how many clients you lock on and still get certified. So I don't feel like I need to do spousal support or give spousal support.
Okay. All right. Thank you. All right. So I'll go ahead and give you my ruling, and then I'll take a little bit of time later today to write it down, and then I can send it to the parties. Let me just double check to
Okay.
make sure I have email addresses of both parties. Generally, those are located at the bottom or the footer of the motions or declarations that you file. I'll double check with first. Ms. Morgan, do you feel comfortable sharing your email address, or do you want me to just send it to your mailing address?
Email address is fine. GIRLEE princess. .com. I'm sorry. I made the email when I was like 12 and I just never changed it.
It's okay.
Yes.
Okay. And Mr. Morgan, as far as the written ruling, do you feel comfortable if I send it to email, or do you prefer US mail?
US mail is fine.
Okay.
And I think,
go ahead.
I think you have my current address, I believe.
Yeah, that's what I'm going to double check. See if we have it here. Oh, yeah.
Sorry about that if that's in my handwriting.
That's all right. Okay, so I'll go ahead and tell you what my ruling is, and then I'll write it down and send it to both parties at those respective addresses.
Okay.
So first off, the 2015 Jeep that goes to Ms. Morgan. The 2019 Coachman trailer and also any associated debt that goes to Ms. Morgan. The Subaru and any associated debt with that goes to Mr. Morgan. The Nissan and any associated debt goes to Mr. Morgan. All those vehicles will need to be refinanced into your own names as quickly as possible. For that purpose, a third party, it sounds like Mr. Morgan's mother, if the parties agree to that, if that'll work out, that you can kind of be the go-between, and both parties are required to cooperate in signing documents, and that third party can assist in that process. The Visa credit card ending in 0973 and any associated debt goes to Mr. Morgan. The Visa card has a balance of roughly $990 that goes to Ms. Morgan. The US cellular bill, I think with that is that sounds like Mr. Morgan has the hardware, so he continues to keep that hardware. He'll be responsible for the continued payment on that. And I think it's important that the parties divide and separate as much as possible. You've made a decision to separate, and so continued involvement doesn't sound like it's going to be the most healthy thing. So, Ms. Morgan, you'll need to get your own cell plan, and Mr. Morgan and Ms. Morgan, you'll have to get separate the account and get Ms. Morgan off. Ms. Morgan.
I think John's gonna say the same thing I am. Go ahead, John.
Okay. Yeah, go ahead.
Go ahead.
I was so sorry, I got a little confused with the first
Right.
part you said. So I'm responsible for my own hardware and she's responsible for hers, right?
If there's hardware that she has that's being paid and is still owed, then she'd need to pay for that.
Okay. And then the other thing is all she really needs to do is just go in US Cellular in Longview. They already have the paper drawn up for separation of phone bill. All she needs to do is sign it, and then they just need to make her own account and stuff like that. So that's all she needs to do is just sign that paper at the store, and then they should help her get a separate phone bill. That's all I needed to add.
Okay. So yeah, you keep your hardware each. If there's any debt, you each get your own debt associated with that. Then Ms. Morgan, you'll get your own cell plan, and Mr. Morgan will stay on the plan that exists, and then Ms. Morgan will be off the account. Okay, and then the fiber loan, my sense there that's a community debt that was incurred for the benefit of the community, including getting the cats fixed and some other moving costs. So that's I'm just going to split that down the middle. Both parties will be 50 for that. It's a joint debt. Both are responsible for that. And so you need to make your 50-50 payment on that particular loan. As far as the storage unit, I think there with the storage unit, it sounds like Mr. Morgan is going to get his stuff out, and I'll just set a deadline that needs to occur prior to August 24th, on or before the 24th of August, that Mr. Morgan will need to get all of his items removed. And both parties are encouraged to have a separate party there just to make sure everybody's acting on their best behavior. And then once he has all of his items removed from the storage unit, then his duty or responsibility to pay for that ends. And then Ms. Morgan can do what she will with it. If she decides to downsize or whatever, that becomes her obligation. Once the cars have been divided up, then each party will be responsible for payment of your own car insurance on the particular vehicles that you have. Then as far as spousal support looks at kind of the idea of spousal support. It takes a look at the length of the marriage. It looks at the respective positions of the party. It looks at need. It looks at ability to pay. It looks at opportunities for retraining or education or the like. What we know is that this relationship was relatively short in comparatively, roughly 4 years. Ms. Morgan, indication from Ms. Morgan is that she's receiving trying to re-up the Social Security. She's getting disability right now. She's working part-time. So it sounds like there'll be increased income coming her way. And then Mr. Morgan is making roughly, from the numbers I looked at, it's roughly about 3,100 a month gross and about 2,400 net. And that's looking at a period of over 15 months, looking at pay stubs and the like. And so here, because it is a short-term marriage and there's not any indication that there's any retraining or desires to get additional education, I'm going to deny the request for spousal support based on that short-term marriage. So that's the court's order. I'll get that down in writing and send that out to the parties. Any questions about the ruling or any clarifications needed?
I do have one question. So are you gonna just, I'm not 100% sure on how this works. So are you ruling it as we're just divorced now, or do I still have to wait 90 days?
No, there's no final divorce at this point. This is kind of a temporary stopgap measure that divides property and responsibility for debt and the like.
Okay.
So,
should we communicate through his mother, or
my understanding is that there's no prohibition or restraining orders or no contact orders in place, correct?
Correct.
Yeah. So I mean, if the parties can communicate, great. If you feel like having a third party would be helpful to kind of keep the peace and keep things moving forward, then I would encourage that. I think that's probably not a bad idea.
I was mainly thinking, like, since he's gonna do 50 on the loan, 50, he should be able to go. I'll tell him this, but if he has problems, he can call me. He should be able to go on Fiverr and pay his half on that loan.
Right.
He should have my account number. It should all just be right there.
Okay. All right. Very good. All right. So I'll get that order out to the parties at latest tomorrow. Well, actually, it could be as late as Monday, depending on how dockets go. I'm not in the office tomorrow, so I'll try to get to you today, but if not, by Monday. Last question, Mr. Morgan.
I do not have access to her account numbers. The only way I can really say that I need something placed is tell the
lady at the desk, pretty much.
yeah, that I just need this money placed in so-and-so's account. I don't have any account number to access her account for that one.
That's all you gotta do. You just gotta walk in there and tell them, hey, I need to put this on this, and say my name. And if you want my account number, I can send it to you because it's nothing, and they can just pull it right up.
Yeah, I prefer not.
Okay, great. Well, I appreciate the parties working together. I'll get the order out to the parties, and then good luck with everything. Thank you. 772-1.
Thank you so much.
See that Mr. Connolly is present. He's here in the courtroom, and then Jessica Giles, are you on the line?
Yep.
Okay, Ms. Giles, does your camera operate? Can you turn that on?
Yeah.
Thank you. Okay, all parties are present. This relates to Mr. Connolly's motion for contempt related to some missed visits during the month of June So I'm familiar with that. And then I read a response that Ms. Giles filed. Mr. Connolly, did you receive a copy of the response? Okay, all right. Where she indicates that there is a Make-A-Wish trip and a trip to Texas, and then concerns related to completion or compliance with some court-ordered services.
Yeah, did you get my declaration that I submitted yesterday?
Did you? So I don't think so. Let me just double check.
They told me a copy just in case.
So the most recent declarations, I'll encourage whoever the party is that's not muted to mute yourself, Ms. Giles. You can remain unmuted.
Okay.
It's somebody else that's making a lot of noise. I'm not sure who it is. So to the individual who's kind in 6192, if you could do me a favor, press *6 to mute. That helped. Nope, that did not help. Okay, that seems to help. Well, that didn't help. Okay, we'll just deal with it. So, Mr. Connor, it looks like I have not read what you submitted. How long is your document there? How many pages?
Like maybe 10 at most, maybe a little bit more.
Okay, did you send a copy to Ms. Giles?
Yeah.
Ms. Giles, did you get a copy of that 10 pages that Mr. Connolly has?
I don't recall.
Okay. So generally, if I'm looking at a 1 or 2 page document while sitting on the bench, I'm fine with that. With 10 pages, that's too much. That's too much. So
One of them is just the declaration, which the declaration is actually only 2 pages. And then the other one.
screenshots of text messages.
Yeah.
Yeah. That's the bugaboo right there. People submit a 2-page declaration and then they have 30 pages of text messages.
Yeah, 2 pages of text messages, I believe.
Yeah.
Or 3.
So, all right. So the issue, I know it's important for the parties to have it resolved. There's a court order that requires visitation. There's an allegation that visitation has not occurred. There's a response to that, and then there's a reply to that response, which I haven't read. And generally, the court rules require timeframes. So as far as submissions, Ms. Giles, her submission was tardily submitted. Yours is tardily submitted. And doing things on the fly and not having time to consider it for both parties, including the court, I don't think is necessarily the best way to do things. So if the parties have filed things, we'll have everybody a little time to digest. I'll get to read it, not being kind of in a pressured situation in a court hearing. So I'll just ask the parties what your schedule looks like next week. And so everybody can kind of just calmer heads, look at everything and be ready for that hearing. Okay.
I'm actually leaving on the 21st to go out of state, just my boyfriend and I, for a vacation. So I'm not available until the 28th.
Okay. Mr. Connolly, do you have any concerns if it was set to the 28th as opposed to the 21st?
I've been set out already so many times. I feel like the sooner the better.
Yeah, it was filed initially
And I mean, it's been, I've had my son in like 4 or 5 months now.
July 2nd. Okay. Let me ask Ms. Giles, pardon the intrusive question, but what part of the world are you going to be on your vacation?
I'm going to Idaho, and I'm being early in the morning on the 21st. And
Okay.
It's like an 8-hour drive.
Okay. Okay. I'll set the matter for the 28th of August, and at 9 o'clock in the morning, we'll address the issues from the parties at that time.
And
Okay.
can I ask a question? I mean, if you want to proceed today, I'm okay with that. But I want to just bring up really quick that on 6/5, when we had the contempt hearing with you and you ordered him makeup visits, and I showed up on Friday at the location and he never showed up and he told me, okay, have a good night. I want to address that because it was a court-ordered makeup visit.
So we address issues that have been noted up for a hearing. Parties have opportunity to read or respond to that. The court has opportunity to read both sides of the story. I read your declaration, Ms. Giles, of what your concerns are related to that. I haven't read Mr. Connolly's response to that. So that would be part and parcel of the hearing on the 28th. Okay, so we'll reconvene then. All right,
Thank you. Is 9 a.m. on the 28th, right?
It is.
Are you going to be able to do both of the hearings at the same time? Because there's one for a change of venue and then it'll be this one. So I just want to make sure those are both going to be able to be done.
Doughton. Okay, thanks.
Yep, they will
All right. So it sounds like is that Damon Doughton that spoke?
Yes.
Okay. Welcome to you, sir. And then Crystal Greeley, are you on the line?
Yeah.
All right, great. Welcome to you. This is a presentation on a motion for the child support post-secondary. We had a hearing previously, and I think that was on it's in the recent past. So I have proposed orders that have been supplied by Mr. Doughton related on an order on motion to adjust child support, a child support order. And then with regard to that, Mr. Doughton, did you provide a copy of that proposed order to Ms. Greeley?
I did, right after it was filed with the clerk. And she had a response to the declaration for that motion saying that she did receive that paperwork from me.
Okay. Ms. Greeley, did you get a copy of the proposed orders from Mr. Doughton?
Yeah.
Okay. And then from Ms. Greeley, I have a proposed order that's an order on motion to adjust child support. It's a 2-page document. And then it says, see attached typed order per Zoom court date of July 9, 2024, agreement per judge. And I don't have the associated attachment that's to go with that. It's not included in the paperwork that I have.
Oh,
So I'm not sure what that attachment says. Mr. Doughton, did you get a copy of Ms. Greeley's proposed order and the attachment?
No, it also mentioned exactly what you said. It said see attached, but there was no attachment with it. I think it was just referring to the previous court documents where the ruling was set, I believe, for the adjustment of child support earlier in the year.
Okay. And Ms. Greeley, is the attachment, is it a copy of, say, like the court minutes that are recorded by the clerk?
it should have had it in it. But it's basically the declaration where you had stated where Damon paid a certain amount, I paid a certain amount, and Kiana paid a certain amount.
Okay. And are those amounts that are within that attachment, are they similar to or different than the numbers that Mr. Doughton included in his proposed child support order?
They are the same as what I put in my declaration.
Okay.
And I think his are pretty similar, besides the talking about payment for the child support part where you had stated he needed to pay that to me, not to Kiana.
Right. Okay. Right. Okay. So it sounds like the numbers are accurate and they match up both proposed orders.
Yes, Your Honor, and we're not disputing the payment amount. After our last Zoom meeting, which was 3 weeks ago, I got some legal advice. They reviewed everything. They mocked up this motion because they said there's some RCWs that were in place that were not discussed that needed to be discussed.
Okay.
As far as she said, under no circumstances, like the child's 18, all the money should go into an account for the child, and then both parents should have complete access to that username and password so that we can make sure that the money is going towards what the statute says it's going towards.
Ms. Greeley, do you have any disagreement with that as far as like the tuition costs and fees at school?
For tuition? No, not at all.
Okay. Basically that guest account for the parents to kind of check in on things and
Yeah.
make sure. Okay. Yeah.
And ideally number on my motion, number 14, number 17 and number 18 was basically the only thing that I wanted to address. Like I mentioned, very important. Our daughter pursues her goal and careers of what she's doing, and I have no dispute for, payment wise. It's just basically some stipulations like that are within those three numbers that I provided with you.
You said 14, 17, and 18?
Yes, sir.
Okay. So Ms. Greeley, I think that reference is being made by Mr. Doughton related to the child support order. And then this is on page 3, starts on page 3, paragraph 4. That's where it says the father should pay the school directly his portion of tuition, $186 per month. And then that talks about the guest account access to the parents. Do you have any objection to either of those items?
No, not for the, nope.
Okay, that seems appropriate. So I'll leave that in. Then 17, end date for support. There's 2 paragraphs there. support indicates there's a limitation of 4 years. And then related, if the child withdraws or leaves school, then the support payments end and not go beyond the child's 23rd birthday. And that's the first paragraph. The second paragraph is that must be in good academic standing. If the child doesn't continue in good standing or withdraws, then it ends, the support ends, and must be full-time. Do you have any concern with either of those two items?
The only verbiage I was worried about with that is if she takes summer off, because that would, have a little gap there. So I just want to make that clear that if she does decide to take summer off, that he would still help her after that if she went back the next quarter.
Okay, Mr.
Yeah, and so along those lines, I was told that, obviously the school doesn't start until September 23rd for fall quarter. So she also mentioned, my legal representative, that I should only be paying the additional amount while she's in school. The tuition, yes, throughout the whole year, absolutely. But while she's not in school, I shouldn't be paying the additional expenses. And that's why the verbiage in there said the 6 payments for the 6 months while she was the additional support of the $234.80 each month on top of the $186.
Where's that at? Where is that addressed?
Let's see. So number 14, it says 6 payments for child post-secondary support should be made directly. The 6 is in parentheses right after the RCW.
Under paragraph 14?
Yes, sir. Yeah, it says pursuant to RCW 29.19.090, and then the paragraph 6 payments for child support should be made directly if feasible. And from my understanding, she told me that's what it was. That why she's not in school, that the $234.80 should not be constituted, and only the $186 should be the 12 equal payments throughout the year to pay for the tuition.
Where is that distinction drawn in your proposed order?
No, that's what she mentioned, that she said that's what the verbiage was for that. Let's see. Maybe that's not in there, Your Honor.
Yeah, and then one other issue related to that. When a young person is going through school, say they enroll in fall and then they do winter, they complete that and they complete winter, and then generally summers are dedicated to earning money so that they can pay for their living expenses and their portion of tuition come the next fall. So it's kind of this ongoing educational pursuit. So your indication is that during those summer months where the educational pursuit is being kind of supported through the say labor or summer job, that the support should end during that time.
Not for the tuition, just the additional $234 that covered like gas expenses, that kind of stuff, cell phone bill.
Okay.
Not necessarily tuition wise. The $186 per month, which was calculated for the 12-month duration, that would continue for all 12 months regardless, no matter what. It was just the additional amount, the additives, I guess, if you want to call it.
Right. Okay. Ms. Greeley, do you have input on that?
Well, I mean, even if she's not going to school, she still has expenses daily, to live. So I thought that was what that $234.80 a month was for, is to help her out financially.
Right. Let me just pause on that just for a moment. I was looking at page 5 of 11, line 11. It says, this order is non-modifiable as to father. This order shall not be changed regardless of the school, living situation of funds available or funds available to the child. I'm a little concerned about that language, in that I would be limiting myself in the future where I said this is non-modifiable. Life happens, life throws curveballs at us all the time. And so I'm just uncomfortable with that inclusion of that language. So I just want to ask Mr. Doughton, your input on that.
Sure. And it's I think it was just basically in regards to not coming back to court again or Kiana to modify the amount again from what you're setting from today, which would have total, I think, was the $420 per month.
Right. Okay. Ms. Greeley.
That's all that was. So we can't come back and just be like, hey, I want to change it to $800 now a month or. Okay.
Ms. Greeley.
I wouldn't plan to do that. I'm just trying to help her out with college.
Okay. So I'm going to strike that language I think it's an unnecessary limitation. The idea is that courts enter orders, they're expected to be followed, and that they should not be changed but for good reason or good cause. And also there's a tacit understanding that life happens and sometimes there needs to be modifications. I'm not saying that there will be, but if certain situations present themselves, sometimes there needs to be at least the opportunity to have that issue addressed. I'm not saying that it would be ruled one way or the other. So based on that, let me just double check with Ms. Greeley if you have any other objections to the proposed order that Mr. Doughton supplied to the court and to yourself.
The verbiage in 18, the first paragraph, I believe, that says the father shall pay support pursuant to those sections above. Payment shall be made directly to child school if feasible. He added the 42080, which the school is only supposed to get the 186.
Correct.
20. So then the rest of the money that is for her everyday living, is that going to be paid to me as we spoke in the time before, or what's the plan with that? And a time frame, he put September 1st to start.
Looks like paragraph 11 addresses the start date of September 1, 2024.
As we spoke before, you had mentioned to do the 234.80 post-secondary child support monthly to myself so that she didn't have access fully to that, and then help her pay her stuff with it.
Right. And so you're concerned then with paragraph 18, second paragraph is what?
Just how that's going to be, because it just says it's feasible, but the child directly is not feasible. Support shall be in the amount of 420.80 per month, which some of that is the college, obviously, amount, the 186, but the remainder of it, is he going to pay directly to me, or is he wanting to pay it into a account that Kiana and I have together?
It would go into a account that both of us have access, and the judge, we already discussed it and we both agreed to it already earlier, a few minutes ago. All the money would go into an account where both parents have access, and then we could see that the money's going towards what it's supposed to be.
And that's the educational institution account, correct?
Correct.
Which would be the 186.40, correct?
Right, because that's the tuition. That's the tuition payment that Mr. Doughton would be supplying.
So the 234.80, that is the child post-secondary child support monthly, is what I'm about. What does he want his plan to be for paying that? Because that would be separate from the college tuition.
Right, Mr. Doughton.
Yes, as discussed earlier, I'd like all that to go, even if it's two separate child accounts, one for tuition and one for the extra. Like we discussed, I think both parents should have access to it, just to make sure that it's going to all the right places. And if I misunderstood, I'm sorry, but I thought we agreed to this already, Your Honor.
Do you have any concerns with that, Ms. Greeley?
That is fine. So he wants to be on the account that the child support's going to go into for Kiana for her living expenses.
It needs to be a guest account.
So the guest account, we're confusing things, I think. The guest account, my understanding, is the educational institution's account where the child is going to school, and then that is a recipient or receptacle of tuition payments, costs, what have you. Charges would be registered there and payments would be made there. That's the 186 per month that Mr. Doughton would be paying. The separate $234.80 of support for the child, that's where I think what Ms. Greeley is asking about, how that's to be handled, if it would be deposited into a joint account between Ms. Greeley and the child, or if it would be a tri-account, if you will, with both parents and the child on.
Yes, I just like to have access to that. I mean, that money is going to Kiana. Like I mentioned, she's 18 years old, so I would like to have access to that account as well.
Ms. Greeley?
I mean, I guess that's fine. It just seems silly, to have both of us on it. It would just be like child support is now,
Right, but I'm physically making the payments. It's not coming out of my checks.
Okay, let me just write this up with my decision and I'll share it with you.
Okay. And You still bank at fiber?
I still have a bank at fiber, yes.
Kristen, do you have a whiteout I could borrow? Okay, so just so it's clear, I wrote this under 18, second paragraph. At the end of the second paragraph, it said, father shall pay to the educational institution $186 per month. Father shall pay into an account titled to mother and adult child a monthly amount of $234.80. So the reason I'm doing that is that one, we know that the tuition is being paid. The school knows the tuition is being paid. As far as the child support, generally that's the post-secondary support to the child generally is handled through that adult child and kind of oversight through Miss Greeley, who's where my understanding is that that's where the child is living and while going to school. I don't want to have the concern is that Mr. Doughton, not saying that he would do this, but I've seen in times past where there's disagreement with how funds are being spent, and if both parents are on that as title holders, one parent could unilaterally take action that kind of frustrates the overall plan of the support. So that's why I'm just having Miss Greeley and the child be on the account. So that's the payment would need to be made into that account. It's the title holder, the account holders are the mother and the adult child. So let me ask then, as far as the additional concerns about any of the other language on that proposed other order. Otherwise, I think I'm prepared to sign off on it.
That last one, I don't know if the verbiage is correct. I was just going to ask on 18, the very last paragraph where it says, should the child move from mother's home, the child and mother shall each be responsible for 50% of the remaining post-secondary expenses due after father's share has been paid.
Mr. Doughton, did I order that at the hearing?
It was 30%, sorry. Or 40%, I'm sorry.
Mr. Doughton, did I order that at the hearing? Oh, Mr.
Sorry, I was on mute.
Yeah, right.
No.
Okay.
Go
ahead.
I'm not trying. We had agreed that Mr. Doughton would pay, or Damon would pay 40%, Kiana would pay 30%, and I would be responsible for 30% of tuition. So I just didn't know if we could switch that responsible to 30% of remaining post-secondary after Damon pays his portion.
All right, Mr. Doughton.
I guess my biggest concern is that she was to leave the household, not saying she will, but if she is to leave the household and then I don't have access to anything, like, I guess that's my biggest concern. It's just making sure that, obviously all the funding and all that stuff is still going towards the purpose of, or the intent of what it's supposed to go towards. And that's the only reasoning I asked for access of the other accounts.
Right. Okay. I'm gonna strike that language.
Okay.
And not include it. And, hopefully that doesn't rise up, but we'll see what happens. Other than that, any other concerns?
My only other one was that it wasn't addressed. So Kiana was approved for $2,695 Pell Grant. And so there's a language in the can't remember what page it's on, but on the motion that that should be taken off the top of the price.
I think that was in paragraph 18. It says all grants shall be taken off the top before calculation.
When we had our court date earlier, we had said that we weren't going to take that in consideration because she still had all of her books and school expenses, and that is only annually how much she'll get. So she won't get that monthly. She just gets that throughout the whole year to put towards things.
Yeah, and I think that necessarily that's a contribution that necessarily needs to be recognized, that goes towards her support. And we talked about, X number of dollars to attend the educational institution. And then if you get a Pell Grant, that reduces that cost. And so that definitely should be a part of the calculus and calculation. So if there's, if that reduces the cost, then that reduces the cost and that's applied. And then each party is responsible for the percentages and the dollar amounts that we've discussed.
Yeah.
So I think it's important to note that maybe along the lines, maybe a more general language that indicates that the all grants shall be applied to tuition and educational cost pursuits, something along those lines.
Okay.
And so would that change the monthly obligation for the tuition for the percentages?
I don't know. Yeah, I don't know. We didn't really talk about that at the last hearing. So if the parties want to discuss that just further, if it needs clarification, then you could submit some type of an agreed order related to that. If the parties can't agree, then you could submit a motion to further establish that. So I just added the language, all grants shall be applied to tuition and costs imposed by the educational institution.
Could I have you look at the FAFSA? Because I know we had kind of discussed that. Her average annual cost after FAFSA is $5,582. And I believe that's what the calculation was for the 40-30-30 to cover.
Like I said, I'm just going to include that language, and if the parties feel that it's a concern, and if you can work out, if there's not a concern, there's not a concern. If the parties can agree to something, great. If not, then a motion could be brought.
Okay, I'm fine with that.
Okay, so I signed off on that order. Unless there's any last minute items, that'll conclude the case.
Nope, I'm fine.
Okay, Mr. Doughton, great, thank you. Appreciate everybody's help. So we have the parties present. Mr. Dorland, if you take off your hat, please. Thank you. And so we have Mr. Dorland here, welcome. And we have Ms. Anglin present. And we're on today for a restraining order. This is has been brought by Ms. Anglin. It looks like there was a temporary order that was issued. And when I looked at the file, I didn't see that service upon Mr. Dorland had been effectuated as of yet. Do you know if he was served officially with a copy of that order?
Well, I asked the police department to send it over there.
Right. And did you get anything back from the police department saying, hey, we served on this particular date, or we weren't able to serve? No. Okay. Yeah, and when I looked at and that's why I asked, I looked in the file. Generally, if they do, whether they are able to serve or haven't served, they'll file a document that says, hey, on such and such a date, we gave this document to Mr. Dorland, or we weren't able to find him on this date, and they send it back. So at this point, I don't show that he's been given notice of it. So let me just ask.
We're not communicating right now. We're speaking through his father, Gary Dorland,
Okay.
and he had mentioned that because sorry, I'm nervous. The visitation's every first and third Saturday, and so I was trying to arrange to have the kids brought to his house for the visitation, and Gary had said that Eric thought that it wasn't happening because of the restraining order, so I had assumed that they had received it.
Okay, let me check with Mr. Dorland. Mr. Dorland, did you get a copy of the order?
I did, but that was only because I replied to a response from a court date July 10th. That was, I was supposed to get notification for a proposal for like a need for a temporary parenting plan change because I was moving back to state. I had left to get in a apprenticeship program to get into line work because I was right about COVID. So like finding an essential job. And then I took the first job out of that school in Texas. So
Okay.
I agree there had been a need to adjust a parenting plan, but I, in the forms of those, it had said that I refused to give my address, which was untrue. It was, I never had any correspondence or requested address. So I didn't have ample time of when I received it was actually July 10th or 11th. I got in July 10th, the evening of the court into state. And I know that they had those dates because I'm sure through my son, I had communicated as it got closer.
Okay.
So I agree, it was originally 50-50 and all that stuff. There was a need for that, but it went to extreme change of supervised visits, 2 hours on first and third Saturday with my daughters.
Right.
Which for no, like, I know if I could have been here to contest that, I think that would have been ruled much differently. I've never had any issues, safety issues. I know that the concern was just probably a little bit of an adjustment. And I realized that I wasn't going to come in and abruptly disrupt what had become their life pattern, but I did want to seek some reasonable visitation with my daughters. And my son's 18. I mean, I'm working out at the gym with them 5 days a week. You know, so hopefully I took this opportunity because when I filed that, I saw this. The reason they probably weren't able to serve it is because that's the one thing I haven't done on my list of since I moved here is to get my ID changed over now and my my current address that I moved. I work in 2 jobs and, you know, I had to kind of get everything settled. I have a room for my daughters potentially when I get to have them. I don't want supervised visits with my father. you know, I've never had an instance for a need for that. Actually, he doesn't even have a place that's really kid friendly. Whereas I have food and, you know, rooms and a nice clean home. So I'm hoping to find out how to proceed after this, as far as with the guardian ad litem, you know, things like that, because I wasn't even given 20 days notice. I went to a legal advisor and he had let me know some forms. I found out when I dropped those off, there's a couple prequel forms that would be helpful, but I wanted to use this opportunity to address this and maybe I could get some advice moving forward with some urgency, because I, you know, like I said, I realize I have activity, but right now it says Saturdays with, you know, supervised visits unless there's vacation plan or sports. Well, guess what? My kids play sports all the time. Like, you know, and so I'm trying to figure out where to go from there, because that's the issue. I got cut off communication the day before. I was supposed to have one of those opportunities from, I believe, 12 to 2 p.m. And so that's when I did knock on the door because I see my dad was supervised, but I never have seen anything about him being a mediator. We've always had communication up to that point. I think the mother was upset because I, you know, addressed that I'm going to address in court about, like, I was not ever asked for an address. I didn't refuse it. So it got sent to my dad. And I think it was with the intention of me not getting that information to be able to, you know, dispute or stand here and, you know, put my side into it.
So let me jump in. There's a lot swirling about, and then I'll hear from Ms. Anglin. So back in August 2018, there's a final parenting plan put in place, and that's been in place for a long time. Then there was a motion filed by Ms. Anglin in June of this year to a petition to modify that parenting plan. So so that information, she filed a motion for adequate cause. So once the parenting plan is in place, we don't willy-nilly change them. There has to be adequate cause or a good reason to change it. So she said, hey, there's a good reason to change it. So she filed a motion for adequate cause and then supported that with a proposed parenting plan, noted it for a particular docket. And then to give notice or opportunity for Mr. Dorland to hear and have his voice heard, she filed a motion to serve by mail. She indicated, as you said, that you'd moved out of Washington, refused to provide a mailing address. Last known address is the father's house in Longview, Gary Dorland, and gives an address. And so that motion was considered by a different judge, and a judge signed off on that order, said it could be alternate service could be given to Gary Dorland at his address. And then there was a follow-up and said there was a proof of service that Matilda Anglin mailed that order and sent it off. And then the court considered that motion on July 10th, and there was a hearing was had, and Mr. Dorland wasn't present for sounds like, you know, his father didn't give the information to him. So a temporary parenting plan was entered, adequate cause was found, and we heard from Ms. Anglin. That's who we heard from at that hearing. And so that order was granted. And then later on, there was a motion on July 22nd requesting an immediate restraining order be imposed. And those are always done ex parte, meaning only one side is heard. Those are done on kind of an emergency basis. If the order is granted, it's up to a period of 2 weeks. And then within that 2-week period, there needs to be a hearing to make a determination if that temporary order continues on or whether it ends at that 2-week hearing, if you will. So that's kind of where we're at procedurally. So the kind of the backstory that we've been talking a lot about, as far as, you know, we've had this parenting plan, this is a dramatic change. I was out of state, came back, didn't get, you know, service or what have you. That's kind of the background that we have. So today we're here for the motion for immediate restraining order. In order to move forward with the hearing today, there needs to be service, and it has to be. And I think some people get concerned because, like, you're putting form over substance or substance over form, meaning that Mr. Dorland has to be served with an official copy of that immediate restraining order. And there has to be proof that he has been served. And notwithstanding that you have a copy in your hand, it's inadequate service. So generally what we do in situations like this is that that temporary order is extended for a period of time to allow service to occur. And then once service has occurred, then Mr. Dorland would have opportunity to respond and say his piece. And then we'd come back and hear from both parties and make a decision whether that temporary order continues or doesn't continue. So that's kind of where we're at.
Can I ask you a question just going forward?
Sure. Let me, Ms. Anglin had raised her hand, and then we can hear from you.
Well, like you just said, today we're here for the restraining order. If he has concerns about the parenting plan, can he do that at a different time, like file his own paperwork or whatever? Because I'm
So,
just here for the restraining order, right?
right, that's, well, yeah, we are here for the restraining order, and the restraining order, the temporary order indicates the following. It says Mr. Dorland has the supervised visits with Mr. Gary, and Gary, pardon the lack of familiarity, Gary may transport the children to and from the house or from the visits. Otherwise, the third party shall be responsible for transportation. So the supervision is not specified in that particular order, but there is that temporary order that says the first and third Saturdays, noon to 2. So that's kind of the temporary kind of stopgap that we're working under with that temporary, the immediate restraining order. So what I'm in a position to do today. Oh yeah, sorry.
Sorry. So a couple clarification things. It isn't specified third party supervision. It also isn't specific. So am I restricted to my father's house? Like, I don't
Yes,
understand.
that's what I was requesting because
But it
my
does-
children have told
hold
me
on,
several
I-
times.
So we'll take one at a time. That's really important for me that we don't talk
Yeah,
over each other. So I'll hear from you, and then if you have a response, I'll hear from the same.
Because it's not really clear on that to me. It says or third party. I just want to, the reason why I want to ask is because in all honesty, like my dad's not set up for children, and simple things like if I get 2 hours, I don't know, it says for third party.
For the transportation.
Right,
piece.
but so then my question is transportation just for drop off, but I have to stay at the house, like we can't do anything in those 2 hours. Also, it says unless there's sporting events, which I'm not being any communication until like the day of what sporting events might come up. I was told, well, you can figure it out. Well, you haven't even informed me of what you've signed the kids up for, what their league name is, what their team name is. I've attended everything I can so far.
So right now there's a lot of ambiguity. There's a lot of ambiguity. And that's not unusual. It's frustrating for you all because the ambiguity is there. But what we know is that the temporary restraining order is controlling right now for the time being. So what I'm going to do, I'm going to continue that temporary restraining order for 2 weeks. Then you'll need to contact law enforcement to have service. And if you want to, it depends on how you want to do it. If a third party can serve Mr. Dorland and it's not law enforcement and they want to file proof of service, if Mr. Dorland wants to accept service, he can accept service through that third party. That can be done also. But so that temporary order will be continued. Then that'll give Mr. Dorland an opportunity to respond, and then we'll be back for a hearing. The issue of kind of what do we do between now and then? That's kind of the issue. And that's where it's not necessarily, but it's vague. So what we know is that the order indicates the following: that the supervised visits with the children are under Gary Dorland's supervision, which mimics that temporary order that was entered on July 10th to a degree. Because that says the first and third Saturdays, noon to 2. So that's what it is, noon to 2 on Saturdays, and not to interfere with the athletic events. And then Mr. Gary can do the transport for the kids for the visit. There's no indication of where that visit's going to occur unless the July 10th parenting plan indicates that where it would be located. I don't think it sets a limitation.
I put at his house.
I don't know if it says that. Oh yeah, it does. It says that it'll be at Gary Dorland's home. So that's where the visits are for the next 2 weeks, are going to be at Gary Dorland's home.
Next, first, third. So can I file for that same court hearing? Just propose for immediate change in that. That also to provide that just the information that I was not given, the information that I was never asked for my address. Some things I don't know. I want to go forward just properly so that way.
So on the 28th, let's see, today's the 14th. On the 28th, we're going to discuss the motion, pardon me, the temporary restraining order, whether that continues or whether it ends. If it continues, we'll see what it looks like. If it ends, then the July 10th order remains in effect, the July 10th parenting plan, which is a temporary parenting plan. If Mr. Dorland wants to bring a motion to either set that aside or modify it, then he'd need to bring a motion to set aside or modify. So that's kind of where we're at, Ms. Engel. The July 10th order.
He's been gone for 4.5 years. It wasn't, I'm sorry.
That's
It
okay,
wasn't
go
so
ahead.
quick. I moved to Texas for a little while kind of thing. So my children have said that they don't know this man. They want to get to know him on their terms. That's why I did the supervised visits. And I did ask him for his address. I've known this man for 20 years and he can get aggressive. And so I told him I was asking his address to send him an announcement for our 18-year-old's high school graduation. Because I was nervous to tell him that I was changing the parenting plan. And he had told me that at the time he was working in New Mexico and that he could get me a PO box to send it to.
So,
And so I was
so the
waiting
issue,
for
those
that.
issues, we're not getting into all that today. That'll be for a future date. That'll be a future date where Mr. Dorland and you will address that particular issue. At this point, I'm reissuing that temporary order, setting a hearing for August 28th. And the service will need, and the reason I'm continuing that matter is for the purpose of being served, so that Mr. Dorland can be served and that he can have a response to that and we can hear that.
So then in the meantime, because to respect this, what I'm curious about is that I don't see him appointed as a mediator for communication. I really don't I want the information sent to me for the sporting event. So that way, if I'm not getting them, and I think it somewhat does pertain to this restraining order, temporary. If I'm not, I'd like to be able to plan if I get them. I'd like to be able to plan if I'm going to go to their sporting events, because those are the things I'm able to attend. And she has all that information, which I don't.
So I'm not making any orders related to that. This is, as I said, we're going to hear this. We're going to hear from both parties whether the temporary order continues. That's the necessarily hard part that we're in right now. There's the system is awkward at times. It doesn't fit the situation perfectly every time. So we have these stops. So when I'm speaking, I'll finish and you will not interrupt me. Is that clear? Is that clear?
Yes.
Great. So it's not necessarily the ideal situation. So the order is what the order is. We're going to come back in 2 weeks to see if it ends or whether it continues. That's it. So, and then between now and then, Mr. Dorland needs to be served a copy of that order. And so the temporary order right now is kind of as it stands right now. It's the first and third Saturday, noon to 2, supervised by Gary Dorland at Gary Dorland's house. So I'll take a moment just to finalize this continuation of the temporary order until we come back on the 28th, and just confirming that both parties are available on August 28th. Mr. Dorland.
And just to confirm with you that I understood correctly, on that 28th, you said that's when I could also enter that motion for that other stuff beyond, or no?
So what I would inform both parties that there's a local rule 88. So if you go to the Cowlitz County Superior Court website, you'll see a series of blue boxes. They have titles. One of them says rules. You click on rules and then you look for local rule 88. Local rule 88 controls the timeframes of when you file something, how much lead time you have to give, how much time is given for the response, how much time is given for the reply. So in response to your inquiry, suggest you check out that local rule 88 on the Cowlitz County Superior Court website to look at the timing of things. It's probably going to be premature. At the 28th, I don't think the local rules allow for a greater period of time. So it's probably not going to be, you're probably not going to be able to be heard on the 28th because it's generally a 21-day lead time. So, okay. So let me just finish this up. So I think what's going to happen, it sounds like, Mr. Dorland, you do have a copy of the temporary restraining order. So I'm not going to require service. You've got it. You've acknowledged it. So don't need to worry about the service issue. So when we come back on the 28th, what we'll be looking for is your response to that temporary order. So that means write it out, write it down, submit it to the court, send a copy to Ms. Anglin. And then if Ms. Anglin wants to respond to that, then she'd have an opportunity to write down what her response is, submit it to the court, and send you a copy.
Okay, so what's your recommended form of service for that?
So you have to be careful because there's that temporary order that's in place that prevents. So with any type of service, parties can't do the service. So you can't go over to Ms. Anglin and say, you've been served. You have to have a third party do that. And so does she. So you need to make arrangements with a third party. They would deliver those documents to her. So does that help?
Yeah, and one last thing, just to clarify, because what's the proper way for me to obtain the sporting event information so I know, or like how she's going to communicate if they're going to make it to my dad or not?
So it's kind of a stopgap until we come here back on the 28th. You could use a third party. Any concerns about using a third party to
Dad agreed to kind of be the mediator.
Okay. Could you give that information to your father? Could you get the information to the father?
ever there is something, and currently right now, there's nothing at the moment this week or anything, so.
Okay.
As soon as I get the schedules and things, I send them to his dad.
Okay, will that work out okay for the next 2 weeks?
I think I could give her a phone. Third party, 'cause that's the person I live with, so just it'd be easier for me to.
So right now, the court, you know, there's a court order that requires Gary Dorland to act as the supervisor. So there's an indication that he could serve in that capacity. So I would just encourage you to use Gary Dorland for that purpose, and hopefully that will work out. All right, so I'm just going to just sign this document that sets the matter over 2 weeks to the 28th of August at 9 o'clock in the morning. And then we will decide on that date, the motion, whether that temporary order ends or whether it continues. And then it sounds like Mr. Dorland will be doing other paperwork related to a motion related to the parenting plan. So at this point, any questions from the parties? Okay.
Who might I speak with about just to verify the forms that I have correctly, the process, or where would I check just to make sure?
Couple different resources. You can go to a place called WashingtonLawHelp.org. WashingtonLawHelp.org is a really good resource. Another resource is the local law library here. It's all computer, but they have different resources. And then another is the Washington State Court website. It has a forms section. So if you just type in Washington courts and then forms, it'll pull up that bank of different forms that you can look at. The third resource is the courthouse facilitator. It's an employee of the clerk's office. They can review your paperwork to make sure you have all the necessary forms or necessary items and that they're complete. You're welcome. Okay, we'll see everybody on the 28th. Thanks. Okay, we have Ms. Brimmer's present. No, pardon me, Ms. Herring's present. Sorry about that. She's present here. And then Garrett Brimmer, are you on the line? All right, Mr. Brimmer, if you're on the line, if you'll please unmute and state your name so I know that you're present. Okay, no response from Mr. Brimmer. So we're here related to child support. It looks like previously the parenting plan was entered and that's been signed and filed. Then related to it was noted that it was on today for a child support motion. And I wanted to ask Ms. Herring, did you submit information about finances or proposed worksheets of what the child support might look like, or any child support information?
Yes.
When did you do that? Because I looked through the file specifically for that type of information. I saw there was a declaration about public service that was filed back in November. I saw a petition for parenting plan and child support, but I didn't have any details about what your income is or what his income is, what your expenses are.
That's what the right here. I don't think it has a date.
Can you hear me?
Is this Garrett Brimmer?
Yes, sorry, Your Honor. I was trying to get my stuff unmuted and send it out before.
Okay. All right. Thanks, Mr. Brimmer. I'm glad you're here. Have you been able to hear what we've been talking about?
Yes.
Okay. So I was specifically asking Ms. Herring related to any details or declarations that give me details about child support, incomes, and the like. And when I've reviewed the file, I don't see anything that's been filed. And so I just want to follow up with her and then I'll hear from you, Mr. Brimmer. Ms. Herring.
It's the Washington State Child Support Schedule worksheets, right?
Mm-hmm.
Yeah.
That's one piece, right?
And
When did you file that?
yeah,
When did you file it?
well, I know it was filed and served. We paid to have it served
Okay.
to him.
All right. So I see that there's a declaration of service from Michael Gilman at Emerald Legal Services that he indicates that he served upon Mr. Brimmer a family law calendar notice, a Washington State child support worksheet, and a child support order. And then, so that sounds like he received them. Did you file those with the court?
Yeah.
What day?
I have not.
Because hold on, Mr. Brimmer.
Pushing this out, so it's hard to remember exactly what the date was because they've just been.
Would it be around that same time frame? I mean,
Yeah, the parenting plan and the child support got done around the same time.
okay. So I'll just let you know from what I'm looking at, it's not in my system. Your proposed worksheets and the proposed child support order are not in the system at this point. So that needs to happen. And then also I need information from you in kind of in declaration form of what your income is and the ages of the children and what your expenses are. So there's kind of some more financial information that needs to be supplied that I don't have. So that puts us in a position where I don't know anything about finances for you or for Mr. Brimmer. So I would be operating in a vacuum if we would make a decision today. So that means necessarily not with, so Mr. Brimmer knows what your proposed worksheets are asking for and what the support order is asking for. So if he agrees with that, we could potentially enter an order today. If he disagrees with that, then potentially we would need to have a hearing on that matter. And I would have to be briefed on what your respective positions are. So Mr. Brimmer, I'll give you a moment if you have any questions.
I do not agree, just based off of what I had seen in the mail, or what I got in the mail. They were trying to make me pay somewhere around $4,500 or $4,600 in back child support when I sent her $200 every single week, and that's all recorded over Apple Pay and Facebook Messenger. So I feel like, yeah, I shouldn't agree to anything that requires me to pay back child support when I have been paying child support and not being able to see my son.
Okay. All right. Sure.
I am 100% responsible of our son. He does not see him. He has made it clear that he is not willing to do any of the classes he needs to see him, because he doesn't think he needs them. So I'm fully responsible for him day in and day out. I don't get his help except for the $200 that he gives, but as soon as we got back from court, he faked a no contact order when we both know how a no contact order goes. We both know that it needs to be served and everything. And he had his mom relay a message to me saying that he will not be giving me money because there is a no contact order, which there was no contact order. And it took me calling him, telling him that there is no contact order. You know how that works, and you need to be responsible for your child too. And the amount that I'm asking for is because he makes $40 an hour. I make $17 an hour, and I'm fully responsible for our son. So what it came down to was like $900 something in here. And even if he were to give me $200, that's still a remaining amount of almost $200 that, that he can afford to help us with, living costs for my son, because I'm doing it all on my own. But so the added up amount, what he's not getting is, since I filed this, is about $9,000. Subtracting what he has gave me, it comes to $4,000 remaining that he does owe me.
Okay. All right. So these are all going to be arguments when we have the proper information before the court. So right now, so generally what I've seen in the past, people, both parties would need to submit information regarding their finances, because right now I don't have anything in my case file. So that would include any W-2s or tax documents that would show me what your wages are, or pay stubs. Those would need to be submitted so I know how many hours you're working, what your hourly rate is. And this goes for both parties. And it shows your deductions. So it shows gross and it shows net incomes. And then also some type of declaration that lists your expense. And these are forms that are available on the website that list. Go ahead and put your hand down. You're not a party. I apologize. So then you would submit that information. Both parties would submit that information and share that information with each other, and then file it obviously with the court. And then we'd come back and review that information and make decisions on the child support. So I'll ask Mr. Brimmer, do you have any questions about that?
No, I do not. But would I be able to add something?
It was a little bit garbled, so I'm not sure what you said at the very end.
I don't have any questions, Your Honor, but would I be able to also add something to what she was saying earlier?
So we'll hear your response to what she was saying when we come back at the future hearing, because there's really nothing to discuss at this point because I don't have any information before me. Ms. Herring, do you have any questions?
No, just a comment. I mean, I've gone to the front.
So I'm not asking for comments.
What's about this?
Do you have any questions about?
It's about the information that you're wanting.
Okay. So does it involve a question?
Well, I guess it could be a question, but when I go up there and ask them, do I have everything that I need to bring to you so that there's not time being wasted waiting here for court? This is all they said I needed. So maybe there needs to be a message relayed to them that you need more when you come to court. Okay.
Okay. So then as far as dates to come back, let's set it for 2 weeks to the 28th. That'll allow each party to receive information from the other party. So all parties will need to serve the other party with your information by the 19th. And then any responses to that will need to be, pardon me, let me strike that, sorry. Need to submit it by the 21st, serve the other party by the 21st, and then any responses to that will need to be filed by the 23rd, which is a Friday. And then we'll be back here on the 28th at 9 a.m. And all issues related to child support will be addressed at that time. All right, thanks for your patience. That'll conclude the hearing.
Yes, Your Honor. Thank you.
All right, great. Kirby Young, are you on the line?
Yes, I am.
All right, very good. And Mr. Lawrence is present. Thank you. So we're here on an update related to the reunification counseling. I have notes from each of the hearings going back to the October 2023 order related to reunification counseling for the father and the son. And then a January 31st review of this year, suspending visitation until a greater showing of counseling, reunification counseling to be reviewed on the 13th of March. The indication was that the son was not super excited about continuing the counseling. He was reluctant, but efforts were to be continued regarding the counseling for reunification. A review is set for May 15th. On May 15th, there were some appointments, but not a lot of progress. The counselor had canceled a few appointments, and then a review is set for July 24th, where no reunification counseling had occurred since the last hearing on May 15th. And that indication from Mr. Utter was that he had scheduled those appointments, but they had been canceled for a variety of reasons. So that's a little bit of kind of a thumbnail sketch of the backdrop. So I'll hear from Mr. Lawrence if you have any updated information.
Yes, Your Honor. I had a chance to speak with Patricia Anderson yesterday. She indicated that the last session that Parker and Stevie attended was on April the 16th of this year. So there have been no further visits in the last 4 months. There were appointments that were scheduled, but they were either canceled by Ms. Young or Mr. Utter. There was one that was canceled by Ms. Anderson herself. She had a medical issue, but the appointments keep being canceled at the last minute. Ms. Anderson indicated that the counseling wasn't having some effect when it was going on a regular basis, and Parker was starting to engage with Stevie. But now we have a situation where both of the parties, for whatever reason, can't seem to commit to having a regular session. And at this point, Ms. Anderson feels that it's actually becoming detrimental to Parker to have these scheduled and then have them canceled again. And she recommended to me that the court just simply drop the requirement. And then if at some point in the future, Mr. Utter and Ms. Young can commit to some type of a schedule, then they start it all over again.
Any input, Mr. Lawrence? Thank you for that. Any input from the counselor regarding if the court were to set a date and that no parties are able to change or diverge from that particular date?
Are you asking me, Your Honor?
Yes, please.
I'm sorry, I thought you were talking to them. So can you repeat it, please?
Yeah. I'm just curious. It sounds like, the scheduling and, the concerns for commitment and the cancellations. If the court ordered that the based on the counselor's schedule, that if they occur, every week at, for 2 hours or whatever the counselor is available on a weekly basis, if the court sets that, was there any discussion related to that with the counselor?
No, we didn't talk about basically forcing the issue on this.
And is there I'll get to you in a minute. Is there a recognition from the counselor that it would be beneficial for the child to have this on an ongoing basis? Because that's the underlying basis of the order, is that there's to be this effort made.
Yeah, she did, and there was progress that was actually being made when the counseling sessions were attended, but then it seems like every session after that there was somebody had some kind of a conflict and canceled them out.
Okay. Thanks. Let me check with Mr. Utter. Mr. Utter, there's indication that there may be some, I'll call it commitment issues on both sides as far as making this happening. Can you give me an idea of what your vantage point is related to that commitment and making these reunification counselings a priority, basically over everything else?
Well, your question to Mr. Lawrence was exactly my question the last time I was with you, or somebody was in your place, actually. Was that there be a court appointed time accountability held if it is missed, or somebody can't commit, or last second cancellations. I've been guilty of that because of work issues, work related issues. I had to miss last week because I flew in diversity training from LA, and it was the only day that could do it. Otherwise I couldn't work. So there is those times, and I understand those times that kind of just pop up.
Can I ask you a question on that?
Yes, sir.
So there's a sense, and I don't know if it's accurate or not, there's a sense that the reunification counseling has a lower priority than work commitments. So if that allegation is accurate, then I would not be setting a specific date or requiring specific dates that it happen on specific dates. If we're going to do this reunification counseling, the parties are going to do it. But if there's not a commitment to forego other priorities, then this has in the minds of the parties, this has a lower priority than other things. And if that's the case, then I'm not going to order it. So do you want to speak to that?
Yeah, Your Honor, I believe that is an inaccurate statement that you made there. Parker is number one priority. If I don't have a job, I can't provide for anybody.
Would you have been let go? Would you have been fired from your job if you said, I have to have this reunification counseling with my child? It's really important. And if I don't do it now, I may not get another chance to do it.
No, Your Honor, I'm not referring to the reunification when I speak on that. I was referring to their last week's court appearance that I missed. Oh. That is when I could have potentially been fired for not taking the diversity training or not being able to attend work until I was able to reschedule or fly. Like I said, they came from LA to fly for these classes. As far as reunification, we had it scheduled every Tuesday at 9 a.m. And that was a commitment. Patricia was willing to open up pretty much anything we wanted, anytime we wanted. And we had agreed to Tuesdays at 9 a.m.
So if the court were to order that, would you be able to make that a priority and make every single reunification counseling without fail, barring a medical emergency?
Yes, please, Your Honor, that would be great. I can make that.
Young?
Well, there's a few concerns here. Yes, with the counseling, those are not attended. The last one was in April. They have been canceled by both of us. I've canceled twice, and I have notes of the times that I've canceled due to other children being sick. Every time Stephen has canceled, it has been because of work. This has taken a huge toll on Parker. The time he canceled in May, Parker and I were actually driving to counseling, and I chose to not call and reschedule. When Stephen texted me that he couldn't make it, I let the counselor know. I chose not to call to reschedule. Didn't hear anything from the counselor till July when he had reached out to her. Usually it was me trying to, okay, can we do Tuesday at, 9 again? And, yes, and then she would text me in the morning at 7 a.m. Oh, he can't make it. It's taken a huge toll on Parker, and I've seen the toll. I've reached out to Keith about it affecting him. I've reached out to the counselor that it's affected him. This is almost a year, and great, there was a little bit of progress, but then now there's all this now negative yet again. There was no prior relationship with Stephen or Parker for 10 years, and this has just been a constant letdown. Even his court-ordered support that he's supposed to pay, he's now in the rear with that. It's just, I don't know. I don't know how I feel about it, or, what I could do to help Parker. I mean, I don't know.
Thank you, Ms. Young. Mr. Lawrence, any additional feedback?
No, Your Honor, I think you have the picture well in hand now as to where we're at.
Okay.
Your Honor.
Mr. Utter, go ahead.
I really don't want to go back and forth here, so I'll just make it short. I too have the same text messages from Patricia Anderson. At one time canceled on my way there, and she said I can still come just individually on my own at that point. Before I received that message, I'd already turned around and went back to work. So there is a lot of pointing fingers here. It is going back and forth. And that's why we came here to begin with, was to get the helps of the courts. And we do appreciate everything courts have done and are hoping that the courts will continue to facilitate this and push it further in whatever direction that is.
Right. So this is going to be the last opportunity for this reunification counseling to occur. And I'm going to require that neither party is permitted to cancel the reunification counseling for any reason, barring a verified life-threatening medical emergency. In other words, this takes priority over everything else, including work commitments, including family commitments, everything, other than a verifiable life-threatening medical emergency that absolutely prevents the reunification counseling from occurring. I'm also cognizant I can't control Ms. Anderson and her schedule. If she needs to cancel, then she cancels. That's hard for me to control, and I'm not going to. But here, that's going to be the court's order, is that, and I can't remember who is setting up the appointments, but the appointments need to be set up. They need to be set up for a set time moving forward. If it can't be every day at the same day of every week at the same time, then there'll be a set schedule by Ms. Anderson just charting what those dates and times are going to be. And neither party is permitted under any circumstances, barring a life-threatening verifiable medical emergency. Those counseling sessions will occur. And if any party misses them, then that'll be brought before the court and we can address that under a contempt type motion. The parties will attend and the child will attend. And if the parties choose not to, or there's a cancellation, then we will take a look at just ending things.
Very well.
Any questions about how to proceed?
No.
I'll reach out to said reunification counselor and reschedule that, or there's no crosstalk.
If you would reach out to Ms. Anderson, get some proposed schedule from her, let her know the court's ruling, and then provide those dates to Ms. Young.
Very well.
I'll reach out to her also.
That sounds great. I'm just going to write a brief bench order that indicates the court's ruling today, because I want that to be crystal clear. The order that I summarized from today's hearing is that both parties are absolutely prohibited from canceling reunification counseling appointments with father and son for any reason except for verifiable life-threatening medical emergency. Any deviation from this court or from this order will be treated under the court's power of contempt. So I'll sign that. If the parties have any questions, you can get a copy of that order. Otherwise, I hope that the expectation of the court is clear that these reunification counselings will occur. There will be no cancellations from either party, and that we'll see how things go. Any questions from any of the parties?
When will we come back to check on everything? As far as the counseling and stuff with you, when do we?
I'm loath to set a date. I want it, if the counseling happens, it happens, and then either party can note it up if there's any concerns.
Okay.
Mr. Lawrence, do you find that there'd be value in adding a review date as suggested by Ms. Young?
No, Your Honor.
Okay, let's see if it happens. And if it happens, then the parties can note it up for a review.
Okay.
I expect it will happen, as that is the court's order, and the reunification counseling will occur without any cancellations. It takes top priority over everything else. Thanks.
Your Honor.
Did you have a question, Mr. Utter?
Yeah, my question was the temporary parenting plan was put on hold until this reunification. So as Ms. Young asked about a later date, I guess I'm a little confused. Do we then come back to the courts and request for a date later after some appointments?
That's one yeah, there has to be some reunification counseling sessions occur, and then if either party feels that it would be appropriate to review those reunification counseling in relation to parenting plans or parenting plan, then you could note it up for a hearing on that and ask for whatever relief you're asking for.
Okay, so as of now, there's no further court dates.
Correct.
For us to attend.
Yep. So the ball is passed to the parties to make this happen. And then if there's any adjustments to any parenting plan, then the parties would need to bring that forward.
Very well.
All right. Thank you.
Thank you.
Last
Thank you.
matter. All right. Looks
Thank
like
you
both
very
parties are
much.
present. We have Mr. Kenneth Johnson is present and Ms. Shannon Johnson is present. All right. We're here on the motion for contempt brought by Ms. Johnson. Let's see, just one moment. And this is related to an order issued on April 25th of this year. Reunification counseling between mother and child is ordered. A father shall, within 1 week of the date of today's order, schedule an appointment with the child and the counselor. Petitioner, who is Ms. Johnson, may have professionally supervised visits with the child. So Ms. Johnson's allegations are that there was an appointment set on the 11th of July. There was not confirmation the appointment was canceled. On the 17th, there wasn't a confirmation of the visit and the appointment was canceled. And on the 15th of July, there were some reunification appointments scheduled with Barbara, and that there was cancellations of 2 appointments. And Mr. Johnson indicates that he went to urgent care, he sent a message to Barbara, and there was a request to reschedule, and there was an indication that wasn't quite sure at that time regarding coverage. And Ms. Johnson expresses concerns that she hasn't seen the child in almost 30 days. And there was some allegation related to I had a notation here regarding Grace, who's the supervisor, I think, of the visits, and Barbara, who's the reunification counselor. So that's kind of where we're at. That's kind of just an overview, and it's very, very brief, and I'm sure you have more information, but I read what you had to say. So Ms. Johnson, I'll hear from you. This is your motion, then I'll hear from Mr. Johnson.
So when you ordered the reunification, I ended up finding the therapist. Kenneth requested more time because he said he couldn't find anybody. He's been making this reunification difficult from the beginning. We did meet up with Barbara, and I had 3 visits with Barbara in June and Ridian. My last visit with her was June 26th, and she recommended that we start the supervised visits on top of the reunification therapy. The reunification therapy was going well. She said, you know, she felt it was okay to like throw in supervised visits as well. Kenneth claims that seeing me twice a week is too much for Ridian. And it was as soon as the June 26th, when she recommended that, I didn't see my son again until July 25th. Grace kept trying to reach out to Kenneth to schedule an appointment with him, but he would never respond to her.
And Grace is the supervisor?
Yeah, Barbara actually arranged for her because they worked together. So it was all going to be kept, you know, under the same like therapy.
So let me ask a quick question. So we're looking at the April 25th order.
Yes.
Okay, thanks. Go ahead.
Okay. So he did finally get a hold of Grace. So I have been able to see her. I've had 2 visits with her, even though it was recommended 6 weeks ago that we start doing these visits with Grace. When it's cheaper, and we have to pay the $120 a visit for Barbara. So Barbara said it was more cost effective and I would still get my visits in if we did the supervised visits along with the reunification therapy. But therapy was going really good. And then we went a month without seeing each other. And then when it did come time to us having an appointment, we were back at square one because it had been a month since he had seen me. Where he was back to, he didn't want to get out of the car. He acts really fearful when I see him. I'm concerned.
Can you
he
help?
warms up in a visit, but
Can you help me understand what are the specific dates where you say you were denied, or the visitation or the appointment did
July
not happen?
11th, July 15th, July 18th, and August 5th.
So was that in your motion? Did you include the August 5th date?
I think I filed it before August 5th.
Okay.
So,
All right. So we're dealing with the July 11th, 15th, and 18th.
Yes.
And so on the 15th, on the 11th, I have a pretty clear picture from your pleadings of what happened there. And then on the 15th, that was a reunification appointment with Barbara, and then that was canceled.
Yeah,
And then on the 18th, what's your allegation there? I don't have notations
that
of what
was
that is.
a supervised visit.
Okay. So that's a supervised visit. On the 15th again, that was with Barbara
That was with Grace.
on the 15th.
Yes. Because then it wasn't till,
So I had from your pleadings that the 15th, that there was a reunification with Barbara scheduled on the
oh, maybe
15th.
it was, okay, I'm sorry. There is a lot of dates. I'm sorry. Sir.
And then the 11th was a supervised visit date.
Yes.
Okay. All right, thanks. Mr. Johnson.
Okay, so I'd never had contact with Grace. My first contact with her was via text messaging on the 17th. I responded on the 19th saying, yes, absolutely. Nice to meet you. She responded back to me on July 22nd. And we had set a meeting for the 24th, I believe.
Mhm.
And Radian was having an emotional time getting out of the car. Grace came out, saw the distress. She decided to cancel that one.
That was on the 24th.
Yes.
Okay.
So she canceled that meeting, stating maybe we should wait for a GAL. And I asked if there was one appointed, and I said, no, we've asked for one, but it hasn't been granted, I guess. I'm not quite sure. But we do not have a GAL. So she canceled that one. We've been to every meeting since. He does not want to do these reunification counselings. He believes it's too often, and he shows signs of anxiety, upset stomach, diarrhea, and just does not want to go, but we still go. And I voiced these concerns to Barbara. I can voice them to Grace, but he still goes. He'll begrudgingly do it because he's told he has to. And I've made them aware if he's put in a position where he's told he has to do it, then he'll do it. But he does not want to, and he'll say that himself.
So I understand that on the 11th, you say that you weren't notified of that supervised visit because you didn't have communication with Grace until the 17th.
Correct.
And you indicated on the 15th that there is an urgent care issue on the 15th, and that's why you weren't there with Barbara.
Yes.
And then on the 18th, what's the information there?
So after I went to urgent care, my phone stopped working. So I tried to go to Verizon or Xfinity, get my phone worked on. My screen was not responding. I wasn't getting text messages. I wasn't getting voicemails. So I was asking, how to fix this. I was waiting for a new phone. They popped in a new SIM card, and obviously that worked. That's when I got all the messages. And that's when I made contact with Grace on the 19th, as well as Barbara on the 19th as well, saying, hey, my phone was acting up. I apologize. Please tell Shannon I'm sorry. And then we rescheduled, and we've made every appointment since. And we've scheduled it to be every Wednesday at 5:15.
So when did your phone stop working?
Stopped working on the 16th.
And so tell me that they didn't have a phone in stock, or they had to order one, or did you?
We had to order one.
Okay, and then you got it when?
I got it back on the 19th.
Okay.
And that's when I responded back that's when I responded to Gracie for the first contact, telling her, hey, I'm sorry, I had little phone issues. Then she responded back to me on the 22nd saying, okay, let me check with Shannon and get some supervised visit scheduled.
Okay, all right, thank you.
Mhm.
Ms. Johnson?
Yeah, that is about the end of it, just that they were trying to get a hold of him. It wasn't until I talked to Barbara and asked her if she had told Kenneth that like the supervised visits were appropriate and that they were okay. And it wasn't until she said something to him that he reached out to Grace or like responded to her. I do have a concern with the last visit I had though. We saw.
So is that a subject of the contempt
It-
motion? Just trying to narrow the scope of today's hearing.
No, it was just a gun issue that my son told me about.
Okay, so I'm going to limit the scope to what's been filed, and so we'll focus on that. So, okay. All right. I appreciate the parties' input and information that you've shared. So here are the allegations that there was a court order which is issued on April 25th that required reunification counseling to occur between a mother and the child Ridian. And there was given to the therapist that before any type of visitation would occur, that pardon me, I'm just going to, the therapist must ensure the child's emotional state is sufficiently robust to participate in said unsupervised visits, in which okay, so the therapist has that charge to make sure the child is in a state well enough to participate in unsupervised visits. Before that, then there'd be professionally supervised visits, and then those visits could be ended if needs be. So there's an indication that July 11th, 15th, and the 18th, either supervised visitations did not occur, or there's a cancellation with Barbara. So in response to that, Mr. Johnson indicates that he wasn't aware of the July 11th visitation, that he had an urgent medical care visit on the 15th, and that the supervised visit on the 18th was scuttled by a phone not working, and then it subsequently coming back online, and then the visits have been occurring since this time. So in these types of cases, the burden of proof is on the moving party here. That would be Ms. Johnson, and I'm going to find that the burden has not been met. So I'm going to deny the contempt, and it sounds like the parties are on a good path forward now. So I just encourage the parties to move forward with that. So I'm denying the contempt. All right. So that'll conclude the hearing for today, and good luck with things.
Thank you.